Okay, good afternoon and welcome to the Appellate Division First Department. We have over 7 hours of argument time scheduled, so I have to ask you to please limit the time you request to what you really need to make your most salient points and to answer our questions. When I call out each case, you'll stand up and each side will tell me how much time you would like. When you are arguing, as you know, you can take your masks off. When the light turns white, that means you have 2 more minutes. When the light is red, that means your time is up. We ask you to please stop at the end of your sentence. You don't have to stop in the middle of a sentence. But if we have additional questions, we will continue to ask you additional questions. But the red light is really for you to end your thought. So let's start with the call of the calendar. People versus Michael Bennett. Excuse me? Okay, well, I'm going to give you 5, 2, and 5. If we need more, we'll continue asking questions. Thank you. Castellanos versus 57-115 Associates. Yes. Okay, 5, 2, and 5. Thank you. T Children is submitted. Goodman versus IEH Auto Parts. Okay. I guess you see that certainly is working. 5, 2, and 5. Okay. Murray versus Rashid. I believe I gave you some time, so you can have 5 and 2. Okay, you're the appellant, and is the respondent here? Oh, that's interesting. Okay, well, do you? That's interesting. Do you? Would you still like to argue? Okay, we'll give you 4 minutes. If you need more, that's okay, and the other side is not appearing. Thank you. Bradley versus Bacal. The appellant did not request time. Is the respondent here? Okay. Okay, well, we'll mark it submitted then. Thank you both. People versus Frazier. Okay, I'll give you 6, 2, and 5. Thank you. Ruiz versus Laufrumsuk. Are you the appellant? Are you the appellant? How much time would you like? Okay, respondent? Okay, 5, 2, and 5. Hobbs versus MTA Bus Company. Is the other respondent here? No? Okay, well, I'm going to give you 5 and 2 and 5, and if that doesn't work, if we have more questions, we'll continue on. Thank you. People versus Aziz. Submitted. Pearl Capital versus Berkovich. Okay, and the cross appellant? Do you want anything to, because you have a cross appeal, don't you? And what did you ask for? Okay, so let's do 5 and 3 and 5 and 3, okay? Thank you. Dordonis versus City of New York? You're the city? Yeah, I'm the city, sorry. Okay. Okay. Thank you. We'll mark that submitted. Bloom versus Papadakis and Gonzalez? Okay, and for the respondent? Okay, thank you very much. 5, 2, and 5. Wolf Holdenstein versus 270 Madison.
For the appellant and respondent on the cross appeal, I request 8 and 4, Your Honor.
Okay, and respondent and cross appellate. Okay, I'm going to give you both 6 and 2 and 6 and 2, and we'll see how that goes. 100 and 130 Biscayne. And respondent? Okay, so, and who's the person that's standing up? Oh, okay. Okay. So how much did you ask for? All right, so we'll do 7 and 2 and 5 and see if we need more time on that. Thank you all. People versus Lam Pham. Submitted. AMK Capital versus CIFRE Realty. Okay, we'll do 5, 2, and 5. And finally, Perez versus 1790 Third Avenue. Okay, and that case is also submitted. Thank you. The first case for argument, People versus Michael Bennett. Good afternoon.
Good afternoon, Your Honors. May it please the Court, Jenna Harris from Weil Gotshal, pro bono counsel in association with the Office of the Appellate Defender, representing Michael Bennett. Mr. Bennett's constitutional right to counsel was violated at the post-indictment lineup when a member of the defense team responded to police notice of a lineup by showing up at the precinct but was turned away.
Counsel, does it matter that the attorney themselves did not show up and it was a paralegal that went?
No, Your Honor. We believe that in this case, the defense counsel sent a paralegal to act as his representative at the lineup, who was a member of the defense legal team. He did not personally appear himself, but that does not result in a waiver of Mr. Bennett's right to counsel. There was no waiver of Mr. Bennett's right to counsel, in fact, by either Mr. Bennett or Mr. Bennett's counsel.
But the facts here are very different than what happened in People versus Griffin. You took a look at that case, People versus Griffin?
Yes, Your Honor, we did.
The facts there are really pretty laid out by the trial judge there.
Yes, Your
And
Honor.
in this case here, we don't have anything.
I would disagree that we don't have anything, Your Honor. I think the facts in People v. Griffin are similar to the facts in this case. In the
How? I
sense
mean,
that
in People versus Griffin, you had a private investigator. He was in touch with the detective that was doing the lineup. The lawyer called the police ahead of time, and the private investigator was working hand in hand with the lineup situation. And it just so happened at the end, when everything was said and done, they didn't let him in the room. And he asked, "Why didn't you let me in?" "Well, that's not our procedure." And the court said, "No, you can't do that." I mean, he was knee deep in the whole process. This case here, very far from that.
here, Your Honor, I think that a paralegal is someone that works very closely with the attorney. The paralegal is a trained professional on the defense team, and he's not that far away from a private investigator.
Yeah, but that was never explored at the suppression hearing. I mean, on cross-examination, I looked at the suppression hearing minutes, and there was no sort of, further drawing out or elaboration on cross-examination when the detective said, "Oh, the paralegal showed up and she wasn't let in." And there was no follow-up question to that.
Yes, Your Honor, that's correct, but it's also the people's burden to to establish that there was no violation of a right to counsel here. And therefore, we believe that there was a violation of a right to counsel, and the record is sufficient in the sense to show that. There are many undisputed facts that we can look to in the record. There was a post-indictment lineup of Mr. Bennett was arranged. The defense counsel was notified of the lineup. The paralegal showed up.
Certainly this lineup in question, Mr. Graham being the witness, there were no exigent circumstances, were there?
That's correct, Your Honor. There were no exigent circumstances here to give grounds for the police to either continue with the lineup or to not be able to inform counsel that they were not going to allow the paralegal to enter the room, which again is another fact in our favor that here that the right to counsel was indeed violated. Additionally, a striking point is that the people did not argue that this error was not harmless, which, again, because it's a constitutional violation, is something that should be taken very, very seriously by this court. And in a case like this one, where identity was so crucial, it's clear that the jury struggled with the credibility of the witnesses and the inconsistencies in the testimony, which is also evidenced by the verdict itself. Mr. Bennett's co-defendant was acquitted of all charges, and Mr. Bennett himself was acquitted of the most serious charges. And so the jury's confusion here is very clear. There's even evidence in the record to support the fact that they asked for testimony about the identification of the shooters and the description of the weapons, et cetera, to be read back during deliberations. And given these facts, there's concrete proof of the jury's scrutiny of the witness testimony, and it's impossible to conclude here that Mr. Graham's identification was harmless beyond a reasonable doubt. Turning back to your question, Your Honor, about the difference between a paralegal and an investigator in Griffin, here, again, the paralegal was sent to be a representative and a proxy for the defense counsel.
In other words, counsel, should it matter who you send, as long as the attorney sends a representative?
It does matter, Your Honor. We're not arguing here that anyone off the street or a stranger should be allowed to represent counsel here. This here, it's very clear he's a member of the legal team, and that person should be allowed to be a proxy for counsel. Thank you.
Thank you very much.
Good afternoon. May it please the court, Beth Fish-Cohen for the people. The defendant claims a violation of the right to counsel, but he never alleges that his own attorney was excluded from the lineup.
Well, counsel, this was a post-indictment lineup. He was already in custody, so he had the right to counsel. We can agree on
Absolutely.
that, right? And the attorney sent a representative from the legal team, whether or not anyone else could have appeared other than someone from the legal team. That's an issue for another day. But the attorney did send someone from his team to represent as a representative, right?
That's right. Well, someone came to the precinct and identified himself as a paralegal, yes.
And there was nothing else other than them turning this person away occurred. There was no inquiry, no phone call to the attorney or anything. The lineup just proceeded where he was on this post-indictment lineup, right?
Well, we actually don't really know that much about it because the defense, who of course does not have to preserve a right to counsel, does have to create a sufficient factual record to evaluate or conclusively establish the merit of the claim. And as was brought out during questioning of the defense, when we elicited that a paralegal was excluded, there were absolutely no questions. We know absolutely nothing.
But that's not the burden. That's not, you're putting the burden on the defendant on a constitutional right to counsel. I mean, the thing is that, in terms of whether or not this paralegal was authorized to be there or was, there on behalf of the attorney, I mean, that's something that I think, he says he's there. All right, and the next question is, as my colleague said, there was no exigent circumstances. The police should have found out when the police should have then, okay, let me make a phone call to see if the if you are who you are, and then we'll go from there, right?
You're right that there's no exigent circumstances, but we also know that this was done by a court order, which means the defense was told in advance of when this lineup would
Right,
be.
and they sent their representative, and the representative, for whatever reason, was turned away. Why does the defense have to show more than that?
Because it's a
Hold on. Isn't there at that point, when you send the representative of the attorney away, isn't there a violation at that point?
No, Your Honor, there is not, because right to counsel cases distinguish between lay people and counsel. What he's asking for is an extension of that right to include a paralegal, and that has never occurred.
But doesn't that make sense? Just consider this scenario. Attorney goes, attorney sees something wrong, becomes a witness, so he can't really represent the defendant. So as a policy matter, doesn't it make sense that it be a paraprofessional, investigator, et cetera?
Your Honor, there may be a reason why a paralegal could appear with an attorney, but it is a right to counsel, and in Grice and in other cases,
But does the attorney at the lineup, does that attorney say anything, do anything, or is it merely a passive role of observation?
It is supposed to be a passive
And if it's
role of observation.
So then what more, why couldn't a paralegal also engage in that passive role and then report to the attorney what he or she saw?
We are not saying that the paralegal was incapable of doing this. We're saying that you don't find for the first time on this record that a defendant was deprived of a right that has never existed. Justice Oing brought up the Griffin case, which of course is vastly factually different. And in that case, they said there is no right to have a non-attorney appear, just as there's no ability for the defendant's father to tell the police that an attorney is on his way to the precinct. And that will not stop questioning. That does not constitute entering a criminal matter. There is a distinction between a right to counsel and those who can fill in. And even if this court wished to extend it, this is not the case to do it, because according to Kinshin and McLean, we're not shifting the burden, but saying that if a defendant does not preserve a right, which he does not need to in right to counsel, he at minimum needs to establish the facts to show. If we knew that that anything about this paralegal, that he had contacted the police, that he was in fact a paralegal, we know nothing. This is an unauthorized stranger. We're not even asking in cases where there have been times when someone other than the actual attorney
What's the basis in the record to say he was an unauthorized stranger?
What we're saying is that there
I just want to know what precisely is the basis for the statement you just made in the record.
the fact that the attorney himself never represented that someone is appearing on his behalf. All that happened was a paralegal, unbeknownst to the police, showed up. And we're talking about someone not who's merely calling and saying, this person is represented by counsel. We're talking about someone who's standing in the room with the victims and witnesses, and there's just no authority to extend that in the absence of counsel, to extend that. And if this court wishes to do that, it should do it in a case where we understand what happens and where the defense did what it was supposed to do and follow up on the questions. I see my light is on. Thank you.
Thank you. Counsel, you have 2 minutes for rebuttal.
Your Honors, people's language that the paralegal is an unauthorized stranger is a gross mischaracterization of the record here. The record here is sufficient for you to find that there was a violation of Mr. Bennett's right to counsel. The purpose of a lineup, of having a representative at a lineup identification is largely to ensure that a fair process happens.
So why isn't counsel correct? Police doesn't know who this person is. He just comes up and announces. Why shouldn't there be more under the circumstances?
Under the circumstances here, Your Honor, there should be an opportunity for notice, proper notice was given, that's correct, but there should be an opportunity for counsel to appear or to at least be informed if the paralegal was not going to be allowed to observe the lineup procedure.
Did the counsel's office have any obligation to notify the police in advance to say, I'm not going to be there, but I am sending a paralegal, would you please come date my paralegal? And that seems to be what counsel was indicating, that they didn't know who the person was, they had no advance notice. Was there any requirement that you do that, or is there any case law that you found that says you need to do that?
Not to my knowledge, Your Honor, that there's an additional requirement that the defense counsel's office has to previously inform or inform the police that he personally won't be able to attend. However, there should be a requirement that if the paralegal, the representative sent by the defense attorney, will not be allowed to observe the lineup, that defense counsel is informed of that and given an opportunity to appear. Again, there were no exigent circumstances here that required that the lineup take place at this exact date and time. Mr. Graham himself was incarcerated and could have been provided at any date to do the lineup. So again, the record here is sufficient, and if it is troubling to this court that it's not, it's appropriate here to remand for further fact gathering.
Okay. Well, thank you very much. I know that you appeared today here, Ms. Harris, as pro bono counsel, and we want to thank you and thank the law firm of Weil, Gotshal, and Manges for letting you spend the time on doing this. You did a very good job, and Ms. Fishcone, always nice to see you too. Thank you. Everybody did a good job. Have a good afternoon. The next case for argument is Castellanos versus 57-115 Associates. Good afternoon. You may proceed.
Good afternoon, Your Honors. Robert Whitbeck for Appellant. May it please the Court. This is a case of statutory interpretation, specifically of the building code, which this Court has held is a matter for this Court as opposed to a question of fact. The facts here are essentially undisputed. This incident happened as a result of a slip and fall on a door frame accessing a setback roof. We presented evidence in the form of an affidavit from an expert in support of summary judgment.
But in this particular case, there were two different affidavits. I mean, you did present an affidavit from an expert, but so did your adversary present an affidavit from an expert. They both seem to have differing opinions as to which building code exactly applied and what exactly applied to this particular situation.
That's correct, Your Honor. However, our affidavit covers specifically that 1906 building code did not have any requirements whatsoever for access to a roof and didn't even mention a setback roof. There was only one provision in the building code, and it would be in the first time in 1968 code that actually mentioned setback roofs. And it specifically says that access to setback roof areas may be through a door or a window opening.
No, but in this case, as you know, Ms. Grigg, the expert for the other side, said that this was different than a regular setback roof because it had the HVAC on it and there were drains. There was various service equipment on that part. So that takes it out of the code provision that your expert relied upon.
Understood, Your Honor. However, that specific code provision that is relied upon by plaintiff's expert, first of all, doesn't mention setback roofs. So as a general statutory interpretation matter, they're asking for that provision, their interpretation of that provision, to expressly refute and supersede a provision that actually addresses setback roofs.
Counsel, is it really a question of pure statutory interpretation as you're suggesting, or as my colleague is suggesting? Could it be that there are disputes, there are factual disputes as to setbacks, what's on the roof, that may raise an issue between the competing affidavits?
Respectfully, no, Your Honor, and this actually was already addressed by this court on multiple occasions. The provision that is relied upon by plaintiff's expert is 1004.8, And that provision is found within Title 27, Subchapter 6 on means of egress, specifically exit doors. Now, the building code defines all of those terms, specifically that an exit is a means of egress from the interior of a building to an open exterior space. That's certainly not the case here. It defines an open exterior space as a street or other public space, or a yard, court, or plaza, which provides egress to a street or public space. Again, certainly not the case with this setback roof. This court in DeRosa v. City of New York dealt with, as I'm sure many of you have been to, Monument Park in Yankee Stadium, where there was a similar contention of application specifically to exit stair requirements and exit door access requirements, where they held that that should be applied to Monument Park.
But are those, are the situations analogous? You got Monument Park and a roof. I mean, are there differences between the two?
Your Honor, actually, the differences would militate more toward application in this case. In that case, Monument Park was accessible to the public. In this case, it was not. In addition...
Well, does it matter, maybe not accessible to the public, but authorized for the area of service? And that's why they were on the roof to begin with?
Well, it's our contention that the entire subchapter, means of egress, specifically based on those definitions, would not apply to setback roofs. Specifically, again, egress meaning a path from an interior of a building to an open exterior space. Since that's not the case here, the entire subchapter 6, means of egress, where that provision is found, would simply have no application to setback roofs. So regardless of the wording and the language of 1004.8, it's important to realize where that provision actually falls, because the entire means of egress subchapter can't apply based on this court's rules and based on this court's ruling in DeRosa, as well as this court reached a similar conclusion as to application of exit stair requirements in Tau Nu.
The trial court below based their decision on the issue of notice, not necessarily getting into the issue of the conflict in affidavits. Why do then we need to address that issue?
Well, notice would not be an issue here because the only contention that anything was wrong as per the building code was an excess height differential due to a building code violation, which we claim does not exist. I see that my time is up.
You'll have 2 minutes for rebuttal. Thank you, counsel.
Thank you.
Good afternoon, Your Honors. Respectfully, Peter Barron for the respondent, Castellanos. You know, let me just start out by saying that the lower court made a number of determinations. One, that the defendant didn't even make out a prima facie showing of entitlement to summary judgment legally and factually. And the lower court expressed exactly why, and I don't think defendants have cured that in their perfection of the appeal. Clearly, there are defects that doesn't even rise to the level the court should consider the opposition, but presuming this honorable court does, one issue that the appellant doesn't seem to bring up is why did they have the door there? They had a door there to provide access to the service area. They put the door there. Not only did they put the door there, they allowed my client from the New York City Department of Construction and whatever to be there, and they didn't lock the door. So they gave him the access to the 12th floor. They have a door there, and then they allow these people to go in and out, but they don't.
How do you respond to the argument that that the code sections your expert relies on are incorrect?
Well, first of all, I think that that's an argument at the very least case for myself, for the jury, but clearly my expert makes a strong argument that the sections she's applying retroactively from the 1968 building code do apply to a roof setback, specifically when there's service done. So and the defendant's expert didn't even comment on this in his initial application for summary judgment, and that's why one of the issues why the court turned him down. But clearly, we've made a showing that the issue of whether or not Ms. Gregg, as an engineer, is correct that the service area is a means of, that the service area at the roof setback requires a means of egress, which I think it does, and I think common sense. But even if we didn't have building code violations, and I think we do, we have a number of them that do apply for obvious reasons. Even if we didn't, the law still allows Ms. Gregg to testify, which she did in her affidavit, and hopefully at trial, that there was a deviation from acceptable and proper building construction and design. They had a 13-inch rider. They had no notice, no handrail, no warning. This is so violative of good and accepted safe practices. And once again, I go back to, why is there a door there if there wasn't an anticipation or a
Counsel,
foreseeability?
speaking of actual or constructive notice to the landlord, was there enough notice here of the slippery condition caused by the water, the alleged water that was on the landing?
The water is another theory, and I think there's enough circumstantially to go ahead with that theory. You know, water is something that's not preserved. The plaintiff, I think, covered it in his deposition. He covered it in his affidavit, and I think clearly he said he slipped. This man is an engineer, so I think he knows the difference between a slippery surface and a non-one. So I think the water issue is part of the issue, but when you have the water on top of a 13-inch riser, and it's a recipe with no mats, no warning signs, no handrails, nothing, something like this could and did happen.
Are the two issues, the height of the rise and the dampness, are they conjoined to create proximate cause, or are they separate proximate causes of the accident?
I think they're separate. I think the law is clear that you can have multiple causes of an accident, proximate causes, and I think each one is a substantial factor or proximate cause of the accident, along with the building code violations. Thank you.
Thank you, counsel.
Your Honors, addressing first the wetness condition. First of all, plaintiff also testified that the wetness condition was wetness that was tracked in on the shoes of himself and the 22 people that he was working with going in and out of the setback roof. There is case law indicating that a property owner is not required to give a constant remedy to water being tracked in from outside. By plaintiff's own account.
But in this case, they're doing an inspection, correct?
Correct.
And are there people there on notice, maybe, that there is a wet condition, that the height differential may be dangerous, that maybe something more should be done, mats, et cetera, to protect from a dangerous condition?
Well, specifically as to the slippery or wet condition, the super was not present at the time, and he's testified as to that. If plaintiff is correct that it was tracked in from outside, it would have existed for mere seconds.
But the thing is, they knew that a group of people were coming to do the inspection, that these 20 people did not show up on a surprise. So they knew they were coming to do it. If they saw that it was wet, they could put something in front of the door to make it easier. I mean, they knew there was going to be people traversing inside and outside from the gravel to the vinyl floor, which is slippery.
Your Honor, there's no indication in the record that even plaintiff had become aware of the slippery condition, either outside or on the sill, until literally it happened. So I would contend that there was no opportunity to notice any of that condition. And if I can also address specifically this whether a door was gratuitously provided beyond the requirements of the building code, honestly, it doesn't matter, because the requirement is even by access by a window or through a window. If you want to apply an OSHA regulation, the OSHA regulation says that service areas can be accessed by a ladder, and specifically indicates, I believe, 10.5 to 14.5 inch spacing between the ladders. That would still fall, the 13.5 inches within that. If I may, Your Honors, I just wanted to also point out that specifically 1004.8, the provision that's relied upon, it states only one means of egress is required for outdoor areas used for service, meaning this is within an area and within a subcategory that already requires means of egress. DeRosa states that is not true. It's not an area that would require means of egress, no matter how many, and therefore that can't apply.
Okay.
Thank you very much.
Thank you. Thank you both. Next case for argument, Goodman versus IEH Auto Parts.
Good afternoon, Your Honors. Kevin McCaffrey on behalf of the appellants. As the court is aware, the respondent was awarded summary judgment on liability in this matter. But I think the record reveals multiple issues of fact. It also reveals that the respondent didn't even set forth a prima facie showing. Immediately after the accident, as the court I'm sure is aware, her first statements regarding the accident were the effect that her vehicle was changing lanes at the exact same time as my client's vehicle. And that was the story that she was sticking with at that time. However, after, of course, retaining...
Maybe I'm looking at a different case. Was this a rear-end collision?
Well, actually, no, it was not.
It wasn't a rear-end collision?
No, if you look at the photographs and also the expert...
That's Mr. Miranda, I think, was he behind the bus?
At one point he was, but they were both shifting lanes when the accident took place. So what we have is...
Where was he when the accident took place? He was behind the accessorized bus, counsel. I mean, I don't know why you don't concede that.
Well, he was behind the bus. We know
So
that.
then it's a rear-end collision.
Well, it's not if you take a look at the photographs. There was side impact, and the fact of the matter is we have two completely different statements by the respondent. The first, again, she's shifting lanes, and that's when the accident took place. The second statement, after she retains counsel, obviously, is that she's traveling in one lane for an extended period of time. At that point, at some point, she's suddenly rear-ended for no apparent reason.
Which is what Mr. Miranda said, correct?
Not at all, Your Honor. Look, Mr. Miranda, this has been my case all along. I have to admit, I took all the depositions. I'm very familiar with it. Mr. Miranda had poor recall. I mean, there's the old saying that I'm sure the courts...
Did Mr. Miranda say anything about switching lanes?
No, he didn't remember exactly what happened at all.
So you have an expert who opines that there was a lane switch, correct?
We have an expert who took a look at the photographs and the testimony and said there was a lane switch based on the photograph.
But Mr. Miranda's testimony doesn't support the expert's opinion, right? Because he does, as you said, he doesn't recall.
No, what supports the expert's opinion is the respondent's statements immediately after the accident plus the photographs. So that's where the expert gets his opinion from. It's not necessarily Mr. Miranda's recitation of salient events. It's the respondent's own statements. Not only that, prima facie showing wasn't made in the first instance.
Are you talking about her statements when she went to the hospital?
Oh, that's right, Your Honor, yeah.
I mean, so those statements are not, relevant to care and treatment, so those are, hearsay statements. They don't carry that much weight anyway, but where is there any evidence that the plaintiff ever testified that she was suddenly changing lanes?
Well,
I thought she said she was in the same lane traveling along, and all of a sudden she got hit by Mr. Miranda.
Exactly, right. And that's what we have. We've got a classic issue of fact where I've got a statement given to medical personnel, which I can bring at trial and confront the witness with, and say, hey, why is this statement so radically different than what you gave under oath? And for that to be taken away from the jury, I think, is irreversible.
I'm sorry, counsel. Is there any indication that Miranda had maintained or was maintaining a safe distance to avoid a collision in this case?
We don't know the distance from the cars prior to the accident. All we know
is that there was a rear-end collision. It seems to me that's a prima facie. So you have to now raise an issue of fact. And one way maybe is, I don't know how you do it in this case.
Well, if I may, Your Honor, the one thing that we have, this goes key to the prima facie showing, rather lack of it, there has to be an indication that the front vehicle, the lead vehicle, was in the process of stopping or at least slowing. We know that's not the case because the respondent not only testified that she was traveling at a steady rate of speed, but she also actually submitted an affidavit to that effect.
She's traveling at a steady rate of speed, right. and there's a rear-end collision. I mean, that's what the record seems to be saying.
Right, but the fact of the matter is we don't know that she was traveling directly in one direction. All we know is that she didn't slow down. There was a lane change according to her first statements, and that's when the accident took place. On the one hand, my client most certainly had an imperfect recollection of the events, but their client has two different versions.
You were talking about the pictures of the vehicles. I looked at the pictures. I really didn't see any damage to the bus. So I mean, you say they hit there, they hit there. I don't know where really they hit. I saw a lot of damage to your client's car.
Yeah, no, you're right, Your Honor.
And it was your client was in the front. Of course, this was a bus, so an accessibride bus. So I guess it didn't really sustain that much damage, but I can't really tell that much from the pictures given that situation.
Sure, no, you're absolutely right, Ryan. There actually is very little damage to the accessory bus. The only thing that you can see in the pictures is that there is slight side damage from where the impact took place. So that indicates, in addition to the fact there's side damage with my client's vehicle, that there was, in fact, a lane change, movement of some kind, and that's consistent with the respondent's first story, which was given.
Okay,
The-
we'll give you 2 minutes on rebuttal, okay?
Thank you,
I mean, you
Your Honor.
have already 2 minutes.
Thank you.
Already gave you.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent. There is zero evidence in this record.
Well, counsel, what about this statement at the Richmond University Medical Center in the record that your adversary is indicating that she said that she was switching lanes? How should we view that statement?
Well, my position on that is it's not inconsistent with her testimony. If you look at her statement, she says that she's looking in her rearview mirror and notices a vehicle coming fast from behind her. She switches lanes at the same time as the fast approaching vehicle is switching lanes. It doesn't indicate there's a side swipe, and it never indicates that he's not behind her. He never testified he was anything other than behind her. So the way I look at this is this statement, which is not germane to treatment or diagnosis. So under Mosquito, it's inadmissible unless they bring in someone who can to attest to this is
I
what
must
she
be
said.
missing something in this fact scenario. Your car is still in the front,
Correct.
okay? You're changing lanes, right? The guy in back is changing lanes too.
Right.
He hits your car.
Right.
I don't see what the problem is.
Honestly, you're
unless I'm missing something.
You're missing nothing.
Okay.
And here's the thing. I want to point to you to 170.
Because he keeps saying that it's not a rear-end collision,
No,
but
it
the
is.
fact of the matter is, your car's in front, his car's in back.
No matter how you slice this, it's a rear-end collision. So if you look at
Whoever
one,
changes lanes, whatever, it's still the back car that got.
correct. And in order to provide a non-negligent explanation, you have to explain why you weren't keeping a safe distance under 1129, which he never did, because he always admitted he was behind her. If you look at 172,
I don't recall reading anywhere where there's a claim that, or there's an assertion that your client stopped short.
correct. There's no assertion that he stopped short, and there's no assertion that there was a lateral movement that their expert, it's some fantasy that he creates, that there's a lateral collision, a lateral contact, or that.
It doesn't matter if there's a lateral contact because
understand.
he's still in the back.
That's right. If I could just read you 172 of the record, this really says it all. So it belies any suggestion he's not behind her. It also belies any suggestion that the defendant is trying to overtake the plaintiff. Here's the question. Were you attempting, this is of the defendant, obviously, were you attempting to pass the accessoride bus at any time from the time you first saw him until the crash? No. So you were always behind her, correct. And what happens next? She hits her brake. The brake light goes on and I hit her. So he's behind her no matter how you slice it. That's our position, that it has been, that his testimony establishes summary judgment for us. In addition to his testimony, you have the certified police report at 224 of the record, which shows the vehicle damage codes, which is admissible, and shows that there's heavy frontal damage of his car to the back of my client's car. That is also supported by the photographs at 223 of the record, which shows tremendous damage to the front of his van. I'd like to just point out two things quickly, because my light's going to go on in a second. With regard to this expert that they're relying on at 772 of the record, this court has said this numerous times, just recently in Gaffney, that it's something as incredible as a matter of law if it contradicts every bit of evidence in the record. And here, this expert at 772 comes up with this lateral collision, this lateral contact. It contradicts the photographs. If there was a lateral contact, there would be damage to the left side of the plaintiff's vehicle and the right side of the defendant's vehicle. And there isn't. So it goes against the photographs. So this expert, the defendant never testifies that there was a side swipe. It's directly belied by the vehicle code damage codes in the police report, and it's belied by the photographs that shows the heavy frontal damage. So to that extent, the court properly rejected the expert affidavit. I believe I addressed the federal, the EMS or the hospital, the initial hospital record being not germane to diagnosis or treatment. But one last thing on that, if you look at 771 of the record, it actually says Patient states is a bus driver, and when she was driving, her bus was hit from the back. That's at 771 of the record. So in addition to plaintiff getting summary judgment on defendant's liability, I believe the trial court properly held that there was no comparative fault on the part of the plaintiff and dismissed defendant's affirmative defense of any comparative negligence. Unless there's any other questions, I'll rest on my brief.
Okay, thank you.
Thank you.
Good afternoon again, Your Honors. Very briefly, on the brake light issue, if you look at the testimony, it's very clear. The question is whether or not a brake light was seen at any time. The answer is yes, but he had no idea when, and it wasn't immediately before the accident. So we know that the defendant, pardon me.
Doesn't it kind of make sense what happened here? That your guy,
Well, what makes sense?
Hold on, let me finish. That your guy was traveling too close, brake light comes on, and he runs into the back of the bus.
Well, I think it's certainly one interpretation, Your Honor, but I think what we have here is a situation where the truth was told the first time to medical personnel. We had a simultaneous lane change. Case law is clear that rebuts any presumption against my client, the rear driver, so she can't make out a prima facie show.
But there's no side swipe. Your guy never says there's a side swipe. He doesn't remember what happens. And we know that it's essentially a rear-end collision.
You're right, Your Honor, that it was in part of rear.
I'm sorry.
I'm
Case
sorry,
law,
I'm
I just
sorry.
want to give you your last point. Case law says that a simultaneous lane change does not allow or prevents or precludes summary judgment to plaintiff when it gets hit in the back.
Well, if the plaintiff, or pardon me, if the front driver is not actually slowing down and there's also two lane changes at the same time of the vehicles, it rebuts any presumption against that rear driver. I think the case
Why
law...
is there rebutting the presumption against the rear driver? There's a simultaneous lane change. You're still in the back.
No, that's true, Your Honor. But I don't think that there's
And
any question...
doesn't your guy have an obligation to stay far enough behind to be able to brake when brake lights come on? I mean, that's what I always thought drivers had.
There is that obligation, but those aren't the facts that are here, Your Honor. Those simply aren't. And plus, even if there had been a prima facie showing, we have multiple issues of fact beyond that, which I think, obviously, if the record's looked at...
What is one of the multiple issue of facts?
Whether or not her prior inconsistent statement was what, in fact, took place. And to take this out of the hands of the jury, where I can't question her in front of the jury...
I'm not sure I agree that it was completely inconsistent, but again, you know, those kinds of statements, you know, that are not germane to care and treatment are not admissible unless you bring somebody in or there's some reason to bring it up on cross-examination because the door is open. That's not, you know, that's not a written statement like a regular statement.
And I agree with that, Your Honor. Obviously, trial, we would lay that foundation. On summary judgment context, I think it's perfectly appropriate and admissible, but I'll rest at that unless the court has any more questions.
Thank you. Thank you both.
Thank you, Your Honors.
The next case, Murray versus Rashid. Mr. Rashid, we're giving you a few minutes. Let these two attorneys leave first, please. Just wait. Yep, it's on. Go ahead.
Good afternoon, Your Honors.
Good afternoon.
I'm a self-represented party in this litigation because I cannot afford an attorney. I have no formal training in law. I have a PhD in economics from Columbia University. I work for the UN. And because of my visa status, I am exempt from, or I'm not required to pay income taxes in the US or any kind of tax in the US, including FICA taxes. This background information is very relevant for this case because that's what was missed in the imputation of the incomes. The trial court's order, Your Honor, that I appeal from has number of factual and legal errors. Although I'm not an attorney, I never have training in law, but I did my research. And I see that first and foremost, it imputed the income. My income is $160,000, and plaintiff's income is $140,000. But it didn't provide any explanation how they imputed the income. How the income was imputed, there's no explanation was given. Although I understand court was required to do that. Second, court applied a law that was 236, DRL 236A, 1, which is basically for alimony that governed before 1980. In this case, the divorce commenced much later, and it is not applicable law. Third, court ordered that a maintenance award for plaintiff without calling a maintenance. And if you look at the records and the brief and the appeal that I made, it is clear that a court awarded a maintenance award. And then fourth, the court basically, even if it awarded maintenance, it was required to follow the formula, but it didn't follow the formula. That's in 236B 5A. And as per the formula, her entitlement was 0, for maintenance entitlement was 0. And even I know that the court has a discretion to deviate from the formula, but it required to explain why it was deviating. It didn't provide any explanation.
Sir, wasn't what was going on here, the court was concerned about protecting really the one valuable asset?
Yes.
And that's the apartment? So wasn't that really what was going on here in terms?
Yes, Your Honor, but that's the carrying cost of marital residence. And that was the one that we offered, Your Honor, that there should be some way of, because I had also my living expenses. I moved out, I was forced out of the marital residence, so I had to leave, rent a place, comparable place, and there's no financial means I could have 50% of the carrying cost. There's no means I had. And so we offered that there was considerable amount of asset in plaintiff's hand. She had $236,000. I had $40,000 in my account. It is undisputed in our net worth statements. But we said, okay, part of that marital debt can be met from marital assets that she was controlling, and they refused that. The idea, Your Honor, is that we both have very limited income, and we couldn't afford to have this huge apartment that we invested in, and there was a way we wanted to resolve it, but that was not resolved. Even after 18 months, Your Honor, the case has not been has gone to trial. There's no speedy trial, and basically, I'm still. This burden that court ordered is still hanging on my shoulder as a Damocles sword. I'm on the hook to basically make this payment, which I cannot afford to make. And Your Honor, if you allow me to make the rest of the arguments that.
Well, you have about 40 seconds, so.
Oh, Your Honor, so I would say that this is a case where there's been a huge amount of disregard for the processes, especially even my insurance. I make insurance payments for the children and plaintiff, but it was not deducted from my child support obligation. And child support obligation, before child support obligation was calculated, the court needed to deduct what payment it ordered in terms of carrying cost of the marital residence. It didn't do that either. So only case that I would refer to, Your Honor, is that case Sean versus Jacqueline, presided over by Justice Sunshine. This is the most comparable case, Your Honor. If you look at it, that case has a very clear similarity between our case, and this is where the court denied a maintenance or carrying cost of the marital residence because the income were very comparable. Also, court denied the legal counsel fees because it says that both parties were very much similar income. Your Honor, so I respectfully request the court to vacate the order and remand it to the trial court for recalculation of the child support obligation. Thank you, Your Honor.
Thank you very much. Thank you for coming in and making your argument, and did a good job of bringing our attention to those things. Thank you. Have a good day. The next case for argument is People versus Frazier.
Good afternoon, Your Honors. Shall I begin?
Yes, please. Good afternoon.
Wonderful. Katrina G. Myers from the Office of the Appellate Defender for Mr. Jamel Frazier. Mr. Frazier's conviction should be reversed because the prosecution brought in inadmissible hearsay to bolster the key witness's testimony under an exception that did not apply. There was no proof that Mr. Rubin's statement—
Counsel, didn't the court instruct the jury that they weren't supposed to take it for the truth of the matter asserted, but for just the limited purpose that it was offered?
It's true, Your Honor. The court did issue a limiting instruction, but here the limiting instruction failed to cure the harm that was done to Mr. Frazier. The statement was just not impactful of the jury's perception of Mr. Rubin's credibility. His entire case was about identification. The prosecution's case rested on Mr. Rubin's identification of Mr. Frazier
Well,
as
counsel,
the shooter.
did it matter that in terms of identification, that he was familiar, the complaining witness was familiar with Mr. Frazier outside of this particular incident?
No, Your Honor, that is not impactful of the issue of whether or not the court improperly brought in the bolstering testimony of Mr. Rubin's out-of-court identification of Mr. Frazier as the shooter to Detective Kahn. And it wasn't just Mr. Rubin, it was the detective as well. Mr. Rubin's familiarity with Mr. Frazier is questionable as well. He met him one time outside of court and was familiar with him from a Facebook photograph. So this isn't the sort of relationship that had developed over many long years where they had many notable interactions that would impress someone's appearance and demeanor in
Well,
someone's memory.
It wasn't just a random event. There was a history behind it, right?
Yes, Your Honor, there was a history. Mr. Rubin was not a credible witness, and part of the reason is because of his history with Mr. Frazier. Their history was not nice, to say the least. Mr. Rubin
They had just had a confrontation about a week or two before this, where they recognized each other, had a confrontation, and then left, right? So they just had seen each other, I think it was about 2 weeks before.
That's correct. It was relatively soon before the incident in this case, and it was precipitated by Mr. Rubin trying to pick up Mr. Frazier's girlfriend's daughter from school and meeting with her on 2 occasions without her mother's permission and impersonating her father. Prior to that time, Mr. Rubin threatened to kill Mr. Frazier while he was incarcerated. And Mr. Frazier was not cool about the situation and didn't respond in a way that we would want someone to respond. However, this was a two-way street in terms of the negative interactions that the two of them were having. And it undermines Mr. Rubin's credibility because it gives every reason for Mr. Rubin to have framed Mr. Frazier and to lie about this case. And that's what the defense argued.
Counsel, one elephant in the room is the video evidence. How do you deal with that? I mean, doesn't that take us into the realm of criminals and harmless error?
If you review the video evidence, the actual footage of the shooting is indiscernible. You can't see who is committing the crime.
Well, it confirms the movements of the defendant, though. You'd concede that.
You can see the defendant moving through his girlfriend's apartment prior to the shooting, and he is more than entitled to be at his girlfriend's apartment.
Anything with respect to a gun? Does it show anything with respect to a gun on the early times?
The prosecution argued that footage showed Mr. Frazier checking a gun while he left an apartment. If your honors review the footage, you can't see what he is reaching into his pocket or waistband and pulling out. You can't see it at all. And that goes back to my point about why this bolstering hearsay was entirely prejudicial to Mr. Frazier. Because the prosecution was allowed to bring this in from Mr. Rubin and from a detective, the jury did not have the opportunity to fairly weigh this evidence and evaluate it in a manner without the taint of knowing that a detective heard that Mr. Frazier was the shooter, that Mr. Rubin has been saying this all along. It makes it all the more likely that they would have viewed that footage and saw that gesture as a gun when the evidence simply doesn't demonstrate that that happened. And because it was so irreparably prejudicial to Mr. Frazier, he's asking for a reversal of his convictions on that count. If your honors aren't interested in that claim, we are asking for a sentence reduction to a term of incarcerations that is closer to the prosecution's offer prior to trial of 12.5 years. Mr. Frazier is different than other defendants because he has a demonstrated work history. He has before this offense, he had a steady job as a union worker. He was an iron worker and built the skyscrapers here in the city. And he had his family write to the court, and they offered him all of their support, and still do to this day. He has every reason to want to be a law-abiding citizen upon his release. And those factors, his demonstrated work ethic and his family support, indicate that he would be of a low risk of recidivism. The purpose of punishment isn't served by extending his term of incarceration an additional 5.5 years simply because Mr. Frazier exercised his right to trial. That is unduly harsh, and he is asking for a sentence reduction that is more in line with the prosecution's initial offer of 12.5 years. And if there are no other questions, I'll reserve time for rebuttal.
Certainly.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court, Samuel Goldfein on behalf of the people. First, I'd like to discuss the video evidence, which Ms. Farber described as extraordinary and unusual. He could not remember seeing a case in his entire career when the video evidence was so compelling, and at sentencing, he noted that it was clear to anybody who was watching the evidence at trial that this defendant did exactly
Well, counsel, could you just address the issue of the statement by the police officer?
Yes, at the hospital, the hospital identification. Your Honor.
Yes.
Yes, absolutely. So Rubin and Detective Kahn's testimony about the statement that Rubin gave at the hospital was admitted under two valid exceptions. The first was to rebut this argument at trial that Rubin had recently fabricated his identification of defendant as a suspect because of animosity with their relationship. On appeal, especially in the reply brief, that argument has morphed to be that Rubin was lying from the outset, but the argument at trial was that, and I quote from the defense summation, that Rubin initially says something about an unknown perpetrator that's relying on Martorelli's notes, and then has reason to come up with a name. So the argument at trial was that he fabricated the statement after he spoke to the police at the hospital. So it was admitted to rebut that claim from the defense. Secondly, it was admitted to complete the police narrative of the investigation. Again, in the reply brief, there's a lot of pages spent discussing how that was never raised before the trial court. Demonstrably not true. On page 192, after they had the discussion of rebutting the recent fabrication, the judge lists the ruling that he's going to give the instruction.
Well, counsel, maybe we could accept that certain statements would be admissible for that non-hearsay purpose of the investigation process or completing the narrative, but the specificity in which was this particular statement, why wasn't that too far, and why is that not harmful as opposed to harmless?
I'm not sure that this specific statement was very far. It was simply that he identified the defendant in the hospital in the manner that he identified him. That was, the police needed to complete that narrative. And then as far as harmlessness goes, I mean, there's video evidence. We see Sadler drive by Rubin. She backs up down the street, makes eye contact with him. We have her cell phone records. We know she calls the defendant 3 times in a row. Then we have video surveillance of defendant and his friends and Sadler all going back to defendant's apartment. Defendant goes upstairs. They're in the apartment for moments. They come back out. He inspects an object that's consistent with a gun that's stored in his front right waistband. That's not where people keep their cell phones typically. Then he gets in a car with a car that's distinctive with another the driver who's also distinctive. Those same 2 individuals, gold medallion around defendant's neck, a ring that covers his fingers, his red long sleeve shirt. All of these things are on all of the surveillance videos. You see the medallion glinting.
Is your position then that all of these things were overwhelming in terms of evidence, and so that's what makes the statement harmless?
Well, I think the statement was properly admitted under 2 hearsay exceptions. I guess one, a hearsay exception to rebut the recent fabrication, and then it's not hearsay because it's not admitted for the truth of the matter asserted, but to complete the investigation. So I think that's proper on both counts. To the extent that there would be any problem with that admission, I think on this fact pattern, with the overwhelming evidence of this defendant's guilt, it's completely and entirely harmless. If there are no further questions about that, I would just quickly turn to the sentence. Yes, the people offered 12.5 years pre-trial before the first trial, the mistrial. After that, defendant went on to commit 2 more crimes while his attempted murder charges were pending. He's also attempted to kill somebody else before while 3 accomplices held somebody down. He stabbed them repeatedly in the abdomen. He's denied remorse to various degrees throughout this process. I think that his sentence is fair and appropriate. If there are no further questions, I rest on the brief and ask that you affirm. Thank you.
Thank you, counsel.
Okay, if I can quickly rebut respondents' arguments about bolstering. The argument that the statement should have been admissible to complete the narrative should not be reviewed by the court because the trial court heard that argument from the district attorney's office and rejected it. This statement was admitted to rebut the claim of a recent fabrication.
I'm sorry, counsel, it does appear that she at least acknowledged that it was an argument to be made. It's on page 192. The prosecutor says, also, we want to offer this as to how it formed the investigation. And then the court responds, right. Didn't we draw the inference in that she's saying, okay, that's an alternate reason?
I think Your Honor should revert to the transcript of the first trial that the court does refer to in that caption of the second trial transcript. And if you read that, you'll see that the prosecution put forward 3 arguments for the admission of this testimony. One was to complete the narrative, the other was to rebut recent fabrication, and the other was an excited utterance. The court made it very clear that this statement was going to come in to rebut a recent fabrication. And of course, counsel can ask to bring in statements to rebut a claim of a recent fabrication. Here, the statement that counsel tried to put in, Mr. Rubin's out-of-court identification of Mr. Frazier, was irrelevant because it could not be found to have been made before the motive to falsify arose. It is a statement that's consistent with his trial testimony that was made at some unknown time between the incident and the trial. Without proof that this statement preceded the motive to falsify, it does absolutely nothing to rebut any claim that Mr. Rubin was lying. So what it did, in fact, was simply bolster his testimony. And it did come from Mr. Rubin and Detective Kahn.
Counsel,
And
I don't
yes,
think
Your-
I'm looking at the wrong transcript, just for, parenthetically. This is the transcript of the second trial I'm looking at.
Second trial, I believe it's page 191 and 192. And then for the first trial, it's around page 239 to 245 that the objection comes forward. And I can certainly bring that to the court's attention afterward if you would like me to. And just briefly, Mr. Frazier was never convicted of attempting to murder anyone before this. And if there are no other questions.
Okay, thank you. Thank you both. The next case for argument is Ruiz versus Laufrumzug. I'm not sure I pronounced that right. I did my best.
Good afternoon. May it please the court, Richard Altman for the appellant. The issue here is the vacator of a default in answering a motion to dismiss. This court, I should point out at the beginning, I believe has the option or the right to decide the merits of the motion to vacate the default without necessarily having to find that the lower court abused its discretion. The facts are unusual because the defendant himself nearly defaulted by not responding to the complaint for a year, ignored stipulations that had been given, ignored the obligation to answer, and finally, at the interim here,
Well, finally, the defendant, 10 months after the case was commenced,
yes,
did not actually answer, but instead made a pre-answer motion to dismiss.
made a motion to dismiss. And at that time, the plaintiff had had given birth to a child and was suffering some severe consequences.
And this was in the midst of the earlier part of the pandemic, am I correct?
Yes, she gave birth in May of 2020. And the courts at that time, of course, were closed. And her lawyer apparently failed to respond to the papers and without telling her. So when she found out, in the meantime, she's dealing with issues with the father of her child. She's in litigation with the father of her child and assumed erroneously that her lawyer would be taking care of it. She finds out a year later that he did not take care of it. She discharges the lawyer and files a pro se motion asking the judge to vacate the default. The judge refuses to do so and cites cases involving...
Counsel, once her attorney had gotten an extension to file the papers, and then she never heard from him until, as you said, like a year later, was the plaintiff under any obligation, or should she have been more diligent in looking into why she hadn't heard from her attorney?
Well, that would seem to be, and the answer to that would seem to be colored by the fact that she was dealing with her troubled pregnancy, her troubled birth, and the problems with the father of her child. And I think it's fair to assume that a lawyer is going to take care of something without her having to inquire in between. Again, it was a motion to dismiss. It didn't require necessarily anything from her because it was directed to the merits of the complaint. The merits of the complaint are plain. There is clearly a claim here of defamation, which is supported by case law. And under the circumstances, the cases that the lower court cited for refusing to vacate the default involve very egregious facts where there were patterns of default, where there were patterns of delay and failure to respond on the part of a party who then comes in after the default and asks to be relieved of it.
I mean, wasn't there, I don't know if it was the judge in Supreme Court or counsel's brief, but someone indicated that the plaintiff had not done anything to move the case, but she was waiting 10 months for the defendant to answer or do something, right? Hard to move the case when you don't get an answer.
She was waiting, the case was brought in 2019.
Right.
And so she was waiting, and he didn't respond for 10 months. And then, at that time, she was then hospitalized and then had to deal with the consequences of the birth. And so only finds out later, in the middle of the other litigation that she's involved with, which has no business being brought into this case. I mean, it's putting a burden on her, which is extraordinarily unreasonable under the circumstances. I think that if you look at her pro se motion, I think she does a pretty decent job of explaining the reason for the delay, and the fact that the lower court didn't even reach whether she had stated a meritorious claim is a part of the problem. There's no, the basis for not answering seems perfectly legitimate under all of the circumstances, and to expect her to not only litigate over the rights to her child, but to expect her to litigate this case as well is just asking too much under the circumstances.
Okay.
All we're asking for is the right
Opportunity to
defend
oppose
this
the motion to dismiss.
on the merits.
Okay.
The claim is meritorious, and
Okay, we got it.
that's for another day, but we're
Well-
asking for the opportunity to do that.
We understand. Okay, you have 2 minutes for rebuttal. Let's hear from counsel for the defendant.
Good afternoon. May it please the court. Daniel Zalkowitz for the respondent. I'd like to bring up two first issues. There was not a 10-month delay in answering. We were actually, our office, this is all outside of the record, so it's very difficult to discuss, but our office was retained immediately. We had conversations for about 9 months with the defendants, with the plaintiff's counsel, trying to resolve this matter. They ultimately put in a default judgment motion inadvertently. We opposed it, and we came to—
I thought plaintiff withdrew her default motion.
They did after a court conference because we had to oppose the motion, and the court held a conference, pretty much indicated where it was going to go, and a stipulation was entered. On May 21st, the appellant's counsel reached out to me and requested an adjournment of 45 days to answer. Within 8 minutes, I responded, no problem. Whatever you need, you can have it. We make a lot of talk about law office failure. Just because an attorney doesn't respond to a motion is not per se law office failure. There is nothing in this record that indicates she was not able to get a hold of him at any point in time.
Well, what should she have done?
We don't know. Based on what her papers are over here, it's very clear that she didn't have the financial means necessary to litigate this case. She was actively litigating 2 other cases. She had the ability to—
Well, I mean, that's kind of an assumption outside the record. So she was involved in other cases. I mean.
So, but does that give her the right to ignore a case then that she's—
Well, she had an attorney, right, who, we were all lawyers or, we're all attorneys, and you have a job to do. And is it the plaintiff's obligation to call you every day, hey, did you file your motion? Or as an attorney, could she expect that he was doing his job, and then she comes to find out a year later that he didn't, in fact, do his job?
But we don't know that. That's not what's in the record. That was not in any
Was there a
of the
motion
papers she
filed?
submitted.
Was there a motion filed?
To be relieved as counsel or to oppose our motion?
To
Our
oppose the
motion was
motion.
unopposed, but just because a motion's unopposed doesn't mean it wasn't on agreement of Ms. Ruiz and her counsel not to oppose the motion. Maybe she didn't want to go forward with this case anymore. Maybe.
Well, I mean, so you're assuming that because the attorney, who she had an attorney at that time, because the attorney did not put any opposition to your motion to dismiss, that meant that she wasn't interested in the case anymore?
I think
How about it meant that maybe the attorney, I mean, this is just as possible, isn't it? That the attorney messed up or left the firm or wasn't interested in the case or something and defaulted. When she found out about it, she did within the required statutory 1 year bring a motion to vacate the default.
But let's look at what she actually put into papers, because I think that's equally as important, because we're all making assumptions. The only thing she put into papers is when I was healthy enough to be able to gain access to the NICEF system and look up this case, did I realize that it was dismissed. We know that she was healthy enough to gain access to the NICEF system immediately. She's been filing paperwork over. There is a reason that you have to put in a reasonable excuse. Lawful failure is one of them, but you have to put in details.
How does COVID, and this is really the infancy of COVID, as I recall, how does that fit into what you're arguing?
You know, and I've thought about this.
Would you agree that COVID is something maybe once in a lifetime or
Hope
event?
so.
Or
I've come before this court personally, and I have a case before this court where I've needed more time. I would reach out to counsel and request it. Absolutely. She did not do anything until September of 2021. I think that makes a big difference as well. It was not in September 2020 that she chose to file the motion to vacate the default. She waited a whole extra year afterwards.
Was it still within the statutory time, though?
It is within the statutory time, but she has not brought forth a meritorious, a reasonable excuse. Is COVID, to say that I have a child, I had 3 children
well,
at home.
well, wait. You didn't have a child during COVID, did you?
I had
Did you have a child during COVID?
I had a 7-month-old during COVID.
Okay, so it's a very different circumstance, I would think, especially beginning of COVID, than having children outside COVID.
Respectfully, that's why Judge Kondo turned around and said, you said you have a child during COVID, you supposedly had complications with this, you haven't given us anything, and she's filing lawsuits.
Counsel, you know, what I'm hearing from you is that what's missing from the record is, we're making all these assumptions, what's missing from the record is her statement that she reached out to her attorney to figure out what exactly happened after you gave the 45-day extension, right?
If we're going under lawful failure, I believe yes. Otherwise, she's asking this court to believe that because you're a parent.
Because the email to you on the 45-day extension said, I need 45 days, she's had a baby, I need her to come in and get all the details on terms of how to oppose your motion. I think that's how the email ended. And you said,
My response is, great.
No
You
problem.
want 45 days? You didn't even need to tell me that she had a baby. You can have as much time as you want. We were giving courtesy after courtesy.
I mean, perhaps she could have done better on her pro se motion, including some other things, but, you know, we have to take a look at all the factors here.
So then, really what the factor the court would be looking at is the fact that she had a baby during COVID. Again, we all had a lot of issues. I personally had them as well. But now it gives her till September 2021 to come in and vacate it. I get the statute allows for that to happen, but we're going to forgive a lot of other things that took place in the meantime.
But it's really not forgiving anything. It's just what plaintiff wants is a hearing on the merits.
But at the same time, my client has the right to move on with his life as well. You know, this case went away. A year ago, he moved to Europe. You know, he was in other places. Now all of a sudden he has to come back in 2022 to defend this because she decides she has the financial circumstances. The papers say I need to have the financial means to do this.
Okay.
It does not allow for you to default.
Okay, thank you.
Thank you.
We'll hear from you, Mr. Altman. You have 2 minutes.
Well, apart from the statements that are not supported in the record.
Yeah, but counsel, I mean, it would have been simple enough. I think that to me, it's like there's a lot of assumptions as to what exactly happened in the 45-day period, or when she did have counsel, what exactly happened. We know that the circumstances, what her personal circumstances are at that time. I don't think there's any question about that. But to me, there's like just you know, unfilled questions about where was her lawyer in all this? I mean,
Where was what? I'm sorry?
Her lawyer.
Where was her lawyer in all this? I mean, she had counsel.
We don't know.
We don't know, right?
We don't know the answer.
I would have liked an affirmation where she says, I reached out to my counsel. He has not returned my calls. He hasn't done anything for him. I'm trying to figure out what he did in those 45 days, rather than for all of us trying to figure out what exactly happened.
Well, it's a simple case of law office failure.
Well, we
A
don't know
lawyer
that.
who-
We're
a lawyer
assuming
who-
that. We're assuming that there's a law office failure. We're assuming because there was no opposition tendered, we're going to blame the lawyer for that to happen, and therefore it's all his fault. But as counsel made a good point. He's like, she may not have been cooperating with the attorney, or she may not have been paying the attorney. I don't know. We don't know. That's his assumption. So when you say law office failure, there has to be something more than law office failure.
If I have a plaintiff as a client and I'm faced with a motion to dismiss on the basis of failure to state a cause of action, I don't have to talk to my client. I have a complaint which I have drafted, and I have to show that it states legally cognizable claims. I don't have to talk to my client. I don't need an affidavit from the client. Maybe I do in certain cases, but in a case like this, where it's a defamation case, the only issue is what was actually said. Is it capable of is it susceptible of a defamatory connotation? Nothing more. And if you look at it, and I've
Pretty straightforward.
supported
What you're saying is pretty
there's
straightforward.
no question. An accusation of plagiarism is potentially defamatory per se. So I state a claim. So that's all I had to say. And so that's all the lawyer had to say. So exactly why he didn't say something so simple, it doesn't seem...
It doesn't matter because of what you're
that's
saying.
what I'm
Look,
saying.
it's pretty
It
straight
really
up.
doesn't matter. Again, she was not... Her involvement was not required here. And if they didn't communicate, she was also having a few other issues that she had to deal with in her life.
We understand. Okay, I think we got the points, so thank you both for the arguments and answers to our questions. Have a good afternoon.
Thank the court. Thank you very much.
The next case is Hobbs versus the MTA Bus Company. Good afternoon, counsel.
Good afternoon, Your Honors. May it please the court. Sam Messa for defendant appellants MTA Bus Company and Giovanni Frusciante. We believe there's several grounds that warrant reversal of the lower court's decision. I'd like to discuss the most important first, which is that the record doesn't show that there was any negligence on the part of appellants in causing this collision, and instead shows that co-defendant's negligence was the sole cause of this collision. So for that reason, plaintiff wasn't entitled.
Didn't the co-defendant say or testify that it was partially your fault?
The co-defendant hasn't testified at all.
But,
Did
okay,
you put in an affidavit?
He did not.
in the police report, Mr. Intezar says that the taxi stalled, correct?
That's what the police officer who didn't
That's
witness
what he
the
wrote.
accident wrote in the police report.
That's right. And then
But
you
I don't know
submitted-
what he said.
I'm sorry, but you submitted the police report. You've adopted the police report, so why can't we look at the police report to see whether there's an issue between what was said by the taxi driver Intezar and what your driver said, the bus driver said?
The police report was cited to in our motion papers before the lower court only to the extent that it corroborated the bus operator's.
Oh, I see. So you're picking and choosing what you want to use, but what you don't like, we should ignore.
Well, not necessarily, Your Honor, because if co-defendant did actually say that, as it appears in the police report, then I don't understand why he couldn't submit an affidavit. He had no deposition testimony to corroborate that. The other testimony of all the other witnesses don't corroborate what he says and instead corroborate the bus operator's testimony.
But isn't that weighing testimony? Essentially, you're saying that we should ignore what Mr. Intezar allegedly said to the police officer versus the two witnesses who did actually observe the taxi driver acting in a reckless way.
I don't think it is, Your Honor, because it's an uncertified report. Again, it wasn't cited to as our primary support of our motion. It was only cited to say this is consistent with what all the sworn testimony is in this case. So I don't think it is weighing credibility.
Okay. You want to address serious injury?
Yes, I'll address serious injury. So we established that the plaintiff didn't sustain a serious injury within the meaning of the statute. We had an orthopedic IME that revealed fully normal findings.
I
No
mean, I
evidence
think
of
you
dis-
certainly established a prima facie showing on the serious injury, but the problem or the issue was that the plaintiff also submitted expert reports from the doctors that she saw, who did find that even 3 years after the accident, there were some continuing issues, and that this would at least raise an issue of fact. That's what the court found, and that, why wouldn't that be appropriate?
Well, these doctors' opinions were without an adequate foundation because one doctor saw her 9 times over 3 years, and in the beginning of his affirmation, he references injuries, unspecified injuries. When he starts giving actual diagnosis, it's over a year after the injury, where he says he does surgery on her for de Quervain's tendinitis. He doesn't say what that is. He doesn't say when he diagnosed that. He doesn't say how he diagnosed that.
Sounds like good cross-examination questions.
Well, I think if you're looking at his opinion, he's just throwing out words and nobody knows what they mean because that's what his role is as the expert. I'm not a doctor, so I don't know what this means. He could say she has applesauce disease. We don't know what that means without his medical opinion.
But bottom line is that the treating and the other doctor did opine that there were limitations on plaintiff's right hand, right? 3 years after the accident, age may have something to do with it, but that she had no complaints prior to that. Isn't that sufficient to go to the jury on serious injury?
I would disagree that the record is clear that she had no complaints ever prior to this because she did testify that she broke that wrist as a child. So to take the position...
But you take the plaintiff as you find them, so it may have exacerbated it, but that, you know, that's what happens.
And exactly, and that's why we produced a radiologist's opinion who reviewed all of the imaging and said there's nothing consistent with any traumatic injury. Instead, these findings are degenerative.
Right, and then the plaintiff's doctor came back and said, what they said about degeneration, they specifically addressed that, raising the issue of fact. And I would note that your radiologist in their report basically just said it's degeneration. He doesn't explain what that is either.
Well, I would say that our radiologist explained its degeneration because there's no findings of traumatic injury. And I would also state that neither plaintiff's experts are radiologists. And to the extent that the one expert tries to exclude degeneration as the cause, he does it in a completely conclusory fashion and just says, there's a possibility of degeneration, there's degeneration on the films, but you know what? It wasn't caused by degeneration, her complaints.
Well,
This was caused by the
look,
accident.
one of these people did surgery on her, so he went in, he saw what was there, he said that there was a causative connection. I mean, you're right, we're not doctors, we're lawyers, so they can testify at trial. Let us hear from the other side. You'll have a couple of minutes for rebuttal. Thank you.
Good afternoon, Your Honors. Thomas Grogan for the plaintiff respondent. If permitted, should I address the serious injury issue?
Go whatever you want.
So the plaintiff sought treatment after the accident. She underwent surgery. She underwent physical therapy twice. And her treating doctor also opined that she needed a further surgery. They addressed the issues of degeneration. They found that there was causation attributed to this accident. She had no prior symptoms before this accident. So therefore, you know, we feel that there's an issue of fact since there are conflicting opinions between the defendant's doctors and the plaintiff's doctors.
Okay, how about with respect to liability, apart from plaintiff's lack of fault, how have you shown that the MTA was responsible for this accident?
So you said the...
I'm sorry, how have you established liability in this case, apart from showing that your person wasn't at fault?
There's evidence in the record that the bus struck the other vehicle in the rear.
But wasn't, there was also evidence that the taxi driver was making a U-turn.
Correct.
Right in front of the bus, and the
Correct.
bus driver said, sorry, I didn't see me, came out of nowhere. And some of the people on the bus, I think, someone testified, who was not a party, that some of the people got off the bus and ran after the taxi driver to stop him after the accident, because he was trying to get away. Is that correct?
That's correct.
So what shows that, I mean, other than hitting him in the rear, is that it? That the bus driver was liable?
Yes, that's it.
But wouldn't that, just based on the testimony of the witnesses, suggest maybe that the emergency doctrine would be applicable in this circumstance for that rear-end collision if it occurred the way Mr. Intezar said it occurred?
Correct.
So wouldn't that then be an issue of fact for trial?
For the two defendants, correct, yes.
So you agree that that liability hasn't been established with respect to the bus, correct?
Correct.
Okay.
Okay, anything else? That's it? Okay, well, we'll let counsel
Thank you.
have his 2 minutes in rebuttal.
Thank you, Your Honors. There's absolutely insufficient evidence to establish this as a rear-end collision. The bus operator testified, as you noted, that the co-defendant made a U-turn from the right lane into the path of the bus that was in the left lane. These are two different lanes. He made a sudden U-turn. The bus operator did everything he could to try to stop the bus, but unfortunately he couldn't, and that's the reason for this accident.
That makes sense, but that makes sense. But we still have to consider what Mr. Intezar said in the police report, that his vehicle stalled and he was rear-ended by the bus.
Well, I think this court's prior holdings established that an uncertified police report is not admissible to establish
In
causation.
circumstances where the movement has itself submitted the police report and asked the court to look at it?
I don't believe that we submitted the police report first. I believe that we, again, just cited to it as this is also something that reflects consistently with what the bus operator said. And also, the police report does reflect that
Did you say
there
anything
was,
about it's not certified, it shouldn't be considered, period?
at the lower court,
Right, because that would be the time you would object to the police report.
I don't believe that the issue was raised before the lower
Right.
court, but I would say that the police report reflects that there was an accident that occurred on this day at this location between a bus and co-defendant's vehicle. But the hearsay statements contained within that police report should not be considered on a motion for summary judgment.
Okay, anything else? All right, I think we got both of your points, so thank you very much.
Thank you for your time.
Good afternoon. Next case for argument, Pearl Capital Business Funding versus Berkovich. Good afternoon.
Good afternoon. Good afternoon, Your Honors. Aviva Francis on behalf of Berkovich and Moschila PLC, who's the appellant and the cross-respondent. May it please the Court. The arbitration award should have been vacated because at least one of the instances provided by the Court of Appeals to vacate the arbitration award were present. Based on the award itself, B&B, which I'll refer to as Berkovich and Moschila, has demonstrated that the arbitrator exceeded the contract terms by misapplying the provisions of the management service agreement, by selectively enforcing the contract in favor of respondents Pearl and ABF, and not equally to B&B. The award also demonstrates that the arbitrator irrationally and against public policy provided a ruling that allowed a non-lawyer to maintain attorney's fees despite recognizing that this outcome would violate the Judiciary Law 495.
So let's start with the latter. Obviously, legal fees can't be shared with non-lawyers, but is there evidence in the record before the arbitration that maybe what could have occurred is that it could have been revenue sharing from the back office collection services that were going on? That certainly is not legal fees, right?
Well, the parties' agreement has specifically provided that there would be, the fees would be split on a quarterly basis based on a percentage system. So for the first quarter, B&B got its share. For the second quarter, they got its share. And for the third quarter, they got its share. For the fourth quarter, it was never divided. So Pearl had maintained the entire revenue for the fourth quarter, which had to have consist somewhat of legal fees. And based on the parties' agreement, they had determined how that percentage would be divided. So there's no way that anyone can argue that the full fourth quarter was just for back offices, because the parties had already agreed on how the back offices would be divided versus the legal fees.
But the problem is, I mean, if you were arguing this case in court, we might, from the beginning, things might be a little different. But this was a case that the parties had agreed to go to arbitration. So you went to arbitration. We know the rules are a little bit different in arbitration. They come back with an arbitration award. They argue extensively before Judge Ostrager on the record. And, you know, the arbitrator didn't do what he found. He didn't do anything that would require us to throw this whole arbitration award out, or even parts of the arbitration award out. There's a little bit more flexibility when you go to an arbitration award than when you decide to litigate in court. We know that.
Yes.
How do we really get above that? I mean, there's always a little, you know, I mean, I hear what you're saying. We've read that. We're aware of that claim. It's a good claim, but, you know, they were trying to work everything out there, and this is how the arbitrator did it. I don't know if that's enough to overturn this award.
Yes, Your Honor, I understand
Even if they're illegals, you know, sometimes there's some of the things that the arbitrators find that's not necessarily enough to turn it over.
Right, but there are case laws in this department where the courts have found that if a contract is misconstrued and it's so irrational that the result is unjust, then it should be overturned. So here we have a case where the arbitrator recognized the division of the legal fees and back office, because for the unreported revenue, the arbitrator used methodically the mathematical formula by taking off the expenses and then giving Pearl their share. They didn't award Pearl the entire unreported revenue.
But if the arbitrator found that B&B actually breached the agreement with respect to the fourth quarter payments, didn't the arbitrator have the authority to come up with the remedy? And the remedy here was you don't get damages for that period of time, or as you characterize, legal fees.
Well, there is a concept of if a party materially breached, then the other party doesn't have to perform. But that only works if the other party doesn't want to perform and wants to repudiate the contract. Here, Pearl did the exact opposite. They went ahead and the counterclaim for breach of contract, and now they were awarded on their breach of contract claim, and then they were double awarded, double damages, by being able to keep the fourth quarter of the MSA payment.
Somehow I think when they get up, they're not going to think that they were double rewarded, since they sued for much, much, much more than they were granted in the arbitration award. So I think we'll hear a different story from them.
You commenced the underlying arbitration, right? Your client, B&B, commenced the arbitration, correct?
B&B commenced the arbitration, correct?
Right. And before the arbitrator were a whole host of facts with respect to the MSA, the fee sharing agreement. I have here in my notes that there's some allegation or assertions before arbitration. B&B set up its own separate bank accounts, began placing collections from non-Pearl clients in those accounts, and did not disclose that to Pearl, Capital, ABF until after this dispute arose. So, I mean, this was all before the arbitrator. I mean, he got a full flavor or full facts of what was going on between the two entities, right?
Correct, there's no doubt, and that's why the arbitrator chose to award Pearl for the unreported revenue based on the undisclosed accounts. But in the manner in which the arbitrator awarded for the unreported revenue, that same formula should have been applied to the MSA payment. The reason why the arbitrator only awarded them a share.
But is that a manifest disregard? I mean, again, as my colleague has pointed out, this is an arbitration award. Was there a manifest disregard for the law?
Well, when the contract was read only in favor of one party by going to the payment section and saying, here, Pearl, you're entitled to these payments, but then not awarding that same amount to B&B either as a credit, because Pearl was holding the MSA payments in their bank account. So it should have at least been a credit or an offset. And there's also a provision of, it's irrational and against public policy if you know that the outcome is going to result in a non-attorney law firm collecting illegal fees, which is unlawful.
All right, counsel, let's hear from Pearl, and you'll have a few minutes of rebuttal time. Thank you.
Good afternoon, and may it please the court. I'm Brian Sutherland on behalf of Pearl Capital and ABF Servicing. To go
What about that issue of the, maybe some of what you're been granted were attorney's fees that you're really not permitted to share in? What about that issue? That was a big point that they made, of course.
Right, so what I want to clarify is that the agreement between the parties in the management services agreement was an agreement to divide aggregate revenue. It was not an agreement that some percentage of the revenue that they received was legal fees. It was not that. It was deliberately not that so that the parties could comply with the judiciary law. There was a 9-day...
Wasn't there, in this case, actually, counsel retained to make sure that the agreement, in fact, complied with our ethical obligations here?
Correct, Your Honor. The parties retained outside counsel in order to structure this. They structured an agreement in which they had aggregate revenue coming in, and this was because ABF supplied facilities and non-legal personnel. When B&B left, they took 11 ABF employees with them, so there was a lot of non-legal work going on. B&B law firm received a lot of money for the year 2018, but the fact is, at the end of the day, and after a 9-day evidentiary hearing, the arbitrator concluded that we performed and that they didn't, and that they weren't entitled to a payment for the fourth quarter, not after their numerous breaches, which the justice just described, including solicitation of ABF employees and sending emails to our clients while they were still employees of Pearl Capital and ABF. These were grotesque abuses that they committed, and the arbitrator held them responsible. That's exactly what he should have done. His result was correct, but even if it wasn't, you don't revisit the results of the arbitration on the merits in a judicial proceeding. That's not what you do. What you can do in connection with our cross appeal, though, is something entirely different. And I want to explain what's so different about our cross appeal as compared to their challenge to the merits. They've brought a complete irrationality challenge, but our challenge is based on the language of the arbitration clause alone. And that's an important distinction because the question that we're posing to this court is a purely legal one.
You're relying on the word shall, but what about the word prevail too? Couldn't the arbitrator find that neither party prevailed?
No, because the arbitration clause, it has the word shall. It has the definite article the, so the parties anticipated that the arbitrator would name the prevailing party.
So the arbitrator has to choose a side then? It has to say somebody won here like 0.1% more than the other side won? I mean, really?
Yes, really. That's the legal question. And
so in other words, the arbitrator can't consider sort of our rules with respect to prevailing parties in determining whether or not a party prevailed, and just applying it mechanically. That's what you want an arbitrator to do?
After the arbitrator decided, the arbitrator has to identify a prevailing party. The arbitrator...
And if the arbitrator finds no one prevailed, in effect, by not awarding you fees, isn't that a finding within the arbitrator's discretion?
No, the arbitrator doesn't have discretion to refuse to identify a prevailing party, especially when the arbitrator had already identified Pearl Capital and ABF as the prevailing parties in connection with their claims.
But that's not accurate, because my recollection is that you have claims for millions and millions of dollars, and you received very small amounts on those claims. So if you look at in the context of the big picture of this arbitration, there's an argument to be made, as the arbitrator found, that you were not the prevailing party.
And that's not our challenge. Our challenge is that the arbitrator had an obligation as a matter of contract to identify the prevailing parties, and he didn't do that. He said there was no prevailing party here. But let me,
I didn't see that. Where in the contract did the arbitrator actually have an obligation under the contract to determine who is the prevailing party? Is that actually in the contract?
Well, yes, and here it is. The arbitrator shall award to the prevailing party all costs, including reasonable attorney's fees incurred by the prevailing party in connection with the dispute being arbitrated.
What if he finds that there is not one? Where does it say he has to find one? That's what I'm asking. I read that too, but
We're relying on the definite article the, meaning the parties anticipated that there will be the prevailing party. And now let me get to my important point. It also says that the arbitrator shall award interest on any sums due the prevailing party, and the arbitrator did award interest to Pearl Capital and ABF.
On one of your claims, on one of, not on all your claims. You didn't prevail in the millions of dollars. But on one small discrete claim that you prevailed on and you got interest.
The arbitration clause doesn't say award interest on any claims on which you prevail. It says award interest to the prevailing party. And so it's logically inconsistent for us to be the prevailing party in connection with the claims because we did get interest as calculated, as required by the
So you're
arbitration
either
clause.
the prevailing party on all the claims or on none of the claims, right? I mean, you can't be the half prevailing party, is that what you're saying? You know?
I'm saying the contract required the arbitrator to identify a prevailing party and that we were the prevailing party as demonstrated by the arbitrator's decision to award us interest on our claims. You can't do that without saying that we're prevailing party because that's what the language of the contract requires.
So what you're saying is, I'm trying to understand what you're saying. You're saying that prevailing party status in this agreement is not the synonymous with the prevailing party status that the courts have determined what a prevailing party is in terms of it has to be a factual determination. You're saying just because we got the interest payment, regardless of all the other claims we have that were knocked out by the arbitrator, we're the prevailing party, we're done.
I think that's a big part of it. Prevailing party has the same meaning in both places in the contract. We know we're the prevailing party because we got the interest.
Like my colleague says here, you could have been like 0.01%, you're it, because they got nothing. The other side got no award at all, but you got something, so you're the prevailing party.
Yes, and to address the court's concern, when the case goes back to the arbitrator, that's their opportunity to say, well, they only won by this much, so maybe they don't get very much in attorney's fees.
But didn't you go back
That's totally
to the arbitrator?
different.
I thought you did go back to the arbitrator for that issue, no?
Well, I'm not sure what you mean by go back. Both sides filed motions to modify, and both sides lost.
And this was one of the issues, though, with respect, the attorney's fees issue was brought before back to the arbitrator.
I mean, if this court remands to the arbitrator, if you reverse, then on remand, the arbitrator would decide the amount of fees and could take into account arguments about how many claims we prevailed on and ones we didn't, and so on.
Okay. Interesting. Let's let each side, we'll have 3 minutes for rebuttal, so we'll hear from.
And I'll appreciate the opportunity to come back. Thanks.
Okay.
So counsel, was it a manifest disregard for the arbitrator not to consider the language as cited by your adversary here with respect to prevailing party?
Your Honor, adversary is asking us to interpret the word "the" more than for what it's worth. The word "the" is many times in the contract, and there's nowhere in the agreement where it says that the arbitrator had to choose a prevailing party.
But this, this goes down to, I mean, if we were to, I mean, look, I look at it this way. In terms of what the arbitrator can do, it's a manifest disregard of the law. I mean, he's looking at case law, he's looking, I don't know what he's looking at, but he may be thinking that, well, okay, I have to decide prevailing party status, and that's a factual determination. And in this case here, I'm weighing all the factors here. Nobody's a prevailing party, and that's the end of it.
Correct, Your Honor, and that's been decided.
But he's taking a position, your adversary's taking a position. He doesn't go, he's not allowed to go through, because of this contract provision that we have, the word "the," he's not allowed to go into weighing and looking at all the facts. He's got to just pick one side to be the prevailing party.
And I think additionally, the issue of the interest as maybe some insight as to them being the prevailing party, what about that?
I think my argument there is that prejudgment interest is typically granted generally under the CPLR anyway. I don't think that has anything to do with what the contract says. And Pearl parties did go back to the arbitrator, and the arbitrator said, because you lost the most of the claims, you're not the prevailing party. And that's what Judge Ostriger said also. Judge Ostriger specifically said.
The point was just, it's very interesting. It just raised a very point. You could have been the prevailing party because the arbitrator could have taken a position. You asked for $5 million. You didn't get $5 million. You only got $300,000. Therefore, I'm going to find for the appellant here, you're the prevailing party, and give you attorney's fees.
Yes, Your Honor. We had six
taking his analysis to the most
Yes, I just want
extreme.
Yes, Your Honor. I just want to touch upon, I have 2 minutes, maybe not even left, on the fact that outside law firm was retained in order to draft the MSA was because the parties wanted to make sure it complied with Judiciary Law 495. And based on that, the MSA specifically provided for the revenue to be split quarterly. So it couldn't have been split annually and comply with the MSA and comply with what the outside counsel recommended in order to comply with Judiciary Law 495. So the parties' understanding was that each quarter, some of it would be legal fees and some of it would be back office fee. So the fact that none of the fourth quarter was distributed means that the pro parties, a non-attorney law firm, non-attorneys, retained legal fees. The arbitrator, just in the face of the award, recognized that Judiciary Law 495 was a problem and explicitly said that the pro parties cannot take legal fees because they're non-attorneys. So just by reading the face of the arbitration award alone, you can conclude that it's irrational and violative of public policy because 495 was not met.
I think the next time you do business together, you shouldn't enter into an arbitration agreement, just litigate in court, and then you can make all these very good arguments.
I also just want, if I may, just one more issue is that we also had noted in our papers that the MSA payment was not really addressed in the arbitration award or in the Rule 50 award. The arbitrator just generally said the bonus was not awarded. We're not seeking here the bonus. The bonus was a separate monetary award for the individual performance on Pearl collections. We're only referring to the MSA, the fourth quarter payment. It's not really addressed, and to the extent it's not addressed, this department has allowed it to be remanded to be addressed. PPX Enterprises versus Scepter. If it's not addressed, the questions, it should go back to the arbitrator to be addressed. Thank you, Your Honors.
Thank you.
Do you mind if I address that point because it is addressed?
Oh, go right ahead.
Okay. We raised this point regarding the fourth quarter payments in the post-arbitration hearing brief. That's at pages 412 and 413. The arbitrator accepted those arguments. And that's most clear on page 113 of the record. That's the order on the motions to modify the award. He heard the arguments that they made. He rejected them. It's clear as day.
He rejected yours too, right?
He rejected our arguments too. The difference between ours and theirs is they're challenging the merits, and we're putting a contractual interpretation question in front of the court. It's a pure question of law. Did the arbitrator have discretion to award interest to us as prevailing parties, but not attorney's fees as prevailing parties? That's the legal question that we're posing. It's entirely different than the complete irrationality challenge that they are bringing. And I think this case presents an opportunity to draw a distinction between those two types of challenges and to reverse with respect to attorney's fees and remand to the arbitrator for determination of attorney's fees, where I'm sure the arbitrator would take all of the arguments that the other side wants to make about which claims worked and which ones doesn't into account in a fair and efficient manner. Thank you, Your Honor.
Okay, thank you. Thank you both very much. Okay, the next case is Bloom versus Papadakis and Gonzalez.
Good afternoon, Your Honors.
Good afternoon.
My name is Edward Shore. I'm representing the appellant, Dr. Michael Bloom. The case was dismissed in its entirety by the lower court. Each cause of action was dismissed two of the causes of action were dismissed for the failure to meet a statutory limitation on time for asserting the claim.
Well, it was a contractual statement on time, right?
I'm sorry, sir?
It was a contractual statute of limitation, right?
That's correct. But our position is that there was no contractual statutory statute of limitations because that was found only by virtue of the fact that the lower court, as a matter of law, found that two distinct agreements were a single agreement at law.
How do you break them apart, the three agreements?
The first
agreement,
agreement...
to each other, they were signed on the same day. It seems like it's one big transaction. That's your burden. How do you do that?
That's the case. That's exactly right. And the lower court cited to that principle, but that principle is a contingent principle, as stated clearly in the case of Williams v. Mobil Oil. It's contingent on the intent of the parties if the intent of the parties demonstrates that, in fact, there was not a single agreement. In this case, we had, there are 3 agreements at issue here, one of which is not in contention. But the first agreement is a sale agreement. It's entitled Agreement for Sale of Assets and Professional Practice, a dental practice. It was
Counsel, doesn't the doctor himself say that had he known things were going to go sideways, he would have sold the business for more money, therefore referencing both the ICA and the sales agreement?
Well, that's
his
one of
own
our
admission?
contentions, is that if that actually goes to our third cause of action, where we claim that he was fraudulently misled into agreeing to the global transaction, which the lower court called it a global transaction, that if he had known that he was not going to be paid as he had expected to be paid under the contractor agreement by which he was engaged to attend to patients, he would have asked for more money up front as part of the asset sale of the agreement.
But just go into the interrelation of the 2 agreements. I mean, how should we view that statement?
Well, the first agreement is an totally executed agreement, virtually totally executed agreement. It was executed on the date of the closing. It was for the sale of the assets, which included specifically, as discussed in Section 1 of the sale agreement, assets of the customer list and the goodwill of the practice. That was executed and finished as of appointed time. The second agreement was a totally executory agreement. It was for...
Weren't all 3 agreements executed on August 31st? In 2018?
Responded executed on August 31st. They were contemporary. That's not, we don't contest that they were contemporaneously.
I'm not understanding your point then, so maybe you could just
Well,
explain
the
that
second agreement was was to be executed over the coming 2 years for services, separate and apart.
Again, the subject matter is the sale of a dental practice and how patients are treated after that, correct? In terms
No,
of
I disagree. It's the sale of the dental practice. The second agreement was how the engagement was to occur.
with respect to patients.
With respect
to dental
to
patients.
future, yeah, that's right, the transition
But
to
isn't that the
patients.
same as the sale of the dental practice? It's all
No, 'cause
about patients, what's being sold, the assets?
The assets, which is the
The
patient.
assets, but aren't the assets also the patients?
No, the assets are the patient list, not the patients.
Well, so.
The patient list, the
Okay,
customer.
so fair enough. So
And the goodwill of the practice.
Okay.
Separate from the service agreement, which is for the attending to patients on an ongoing basis.
All right, so let's hear from the other side, and you'll have a few minutes for rebuttal. Thank you, Mr. Shore.
Good afternoon. If may please the court, my name is Douglas M. Lieberman. I represent the appellants, the respondents. Been late already. So just a couple of points that my adversary raised is as far as the idea with intent. In the affidavits that were submitted below, Dr. Bloom admitted that the independent contractor agreement was a condition of this transaction. So I think that's one point that automatically shows the intent that they were to be read, both agreements were to be read together. Additionally, with respect to the point of the executory nature, there was a case that we cited, the DeVos case, where there was an agreement of sale and a promissory note. The promissory note, which is something that's going to be done in the future in this transaction, had a forum selection clause, and the court determined that that forum selection clause applied to the sale agreement. So just because of the fact that there was something that could happen in the future, that in and of itself isn't enough to say there was no intent to hold these agreements together. Now, just to hit a couple of other things that we have,
that we set forth in our brief. One of the things is that we go through all of the points relating to the intent argument that was made. And we believe that we show that these agreements were to be the same. We also believe that even if you found that the agreements were to be read separate and the statute of limitations doesn't apply, that first we start with the first cause of action, the breach of contract cause of action should still be dismissed against both parties. First on the grounds for Dr. Papadakis, because he's not a party to the sale agreement, the PLLC is, and with respect to the PLLC, that also would be dismissed. Because of the fact of this referral argument, which was made that we breached the ethics paragraph of the agreement because of the rules. But we believe that that does not apply to intra-office referrals, which is what this was. It's clear in the agreements that Dr. Bloom, though he was an independent contractor, was performing the services on behalf of the PLLC, and that what he was doing...
Where was he performing these services?
At the PLLC's offices.
Whose equipment was he using?
The PLLC's. So we believe that because it was intra-office, that those rules do not apply. With respect to the conversion cause of action, again, statute of limitations applies. There was a point raised that the conversion cause of action really is a bailment, but again, we do not believe that argument works because of the fact that there were none of the allegations that were made were related to bailment. Also, again, the independent contractor agreement says the services are provided on behalf of the company, which is the PLLC, and that there are also paragraphs where, as far as collections and payments, are all made to the company. As a result, the monies that they're claiming were bailed were never monies of Dr. Bloom. These are always monies of the PLLC. And so as a result, the Dr. Bloom never gave up the possession of something that was his. That's why we believe the bailment argument wouldn't work either. Lastly, just the fraudulent inducement argument as to Dr. Papadakis. We believe that the representations are not representations of a material fact because they relate to something that happens in the future, and we lay out why. But again, even if you find that it is a misrepresentation of fact, there is still the point that that claim is identical to the breach of contract claim. And if you compare the allegations in the complaint of those two causes of action, you'll see that they are virtually identical. Thank you.
Thank you.
With respect to the third cause of action, the allegations are, the claims are not identical. The claims with respect to the activities which created the fraudulent inducement in the first cause of action was presented for the purpose of piercing the corporate veil, as the court has found, the Court of Appeals has found previously, that in a piercing action, the person in chief who actually breached the contract is still liable for the breach, but the individual cannot hide behind the veil of the entity so as not to be liable for the breach. That's as found by the Court of Appeals. The issue with respect to Appellant in his affidavit calling the independent contractor agreement a condition, that was, if you read the provision, that was a vernacular use of the word. In fact, the sale agreement specifically says that the third agreement, not at issue here, the non-compete agreement, is, quote, a condition of this agreement, close quote. Well, the ICA is dealt with further into the agreement, sale agreement at paragraph 8, and it's designated as an agreement to be signed at the closing, much different. It indicates that I would agree that the non-compete is part of the single agreement with the sale agreement, but the ICA is not part of the agreement. And I attempt to discuss 9 different indicia that if the agreements were looked at, 9 different indicia that show that the agreements were in fact meant to be separate and not a single agreement. First, thank you.
Okay, thank you both very much, and have a good afternoon. Next, Wolf Haldenstein versus 270 Madison.
May it please the court. My name is Ethan Cohen from Rosenberg and Estes, representing the appellant's respondents, the landlord of the building at 270 Madison Avenue. The central issues on this appeal are purely questions of law for this court concerning the proper interpretation of the parties' original lease and Sixth Amendment to the lease. The first issue, the parties expressly agreed in 2018 in the Sixth Amendment that all provisions of the original lease are hereby declared to be in full force and effect and binding upon landlord and tenant, that the lease is ratified and confirmed in all respects, and that only in the event that any of the terms of the Sixth Amendment are inconsistent with the terms of the lease.
Was there anything about substantial completion? I mean, in the initial lease? No. We're talking about, this is a renovation of 2 floors while the client, while the tenant moved to 2 other floors. So it's, a lot of this case has to do only with the Sixth Amendment, not with the original lease.
Yes, Your Honor, the Sixth Amendment provides that the tenant was going to remain outside of the premises, not in possession, until 10 days after substantial completion. It does not allow the tenant to take possession and then
but wait, you're talking about to go back to the 9th and 10th floor?
Yes, Your Honor.
Well, didn't they go back to the 9th and 10th floor at your urging because you wanted to demolish the 11th and 13th floor, which you did right away?
Your Honor, the landlord...
I mean, I don't think they took it because they thought everything was hunky-dory when everybody testified that the HVAC system sounded like a jet engine there. Everybody knew about the problem with the HVAC
Yes, Your Honor,
system.
including the tenant. The tenant knew about the problem. They inspected the space.
And you urged them to go back there because you want that you would fix it because you knew you needed to demolish the other floors.
Your Honor, they committed to making repairs to the HVAC, and the tenant here would be entitled to repairs to the HVAC and any actual damages that they suffered from not having the HVAC, which were minimal here. But when they took possession of the commercial premises, which they've been in for the last 3 years, their rent obligation commences for that premises based on 2.4 of the lease. It was not amended or deleted. It was never modified.
But there'd never been anything from the architect saying that we've substantially completed the work. And isn't that a necessary threshold?
Substantial completion was an obligation of the landlord prior to possession. Tenant was not to take possession until 10 days after substantial
And you
completion.
never gave anything in writing to say that there was substantial completion. As a matter of fact, the architect testified at the trial that there was never substantial completion.
Your Honor, this is a matter of, the contract says that if they take possession, they are conclusively deemed to have agreed to landlord's pre-possession obligations. They took possession and...
That argument just completely ignores the Sixth Amendment of the lease. I'm really having a tough time following your argument. I understand what you're saying, but it's tough for me to follow because I keep looking at the Sixth Amendment and what my colleague keeps pointing out, that there's a distinction to be made because there's a substantial completion requirement now, and it is inconsistent with the 1995 lease.
But the requirement was also that the tenant not take possession until 10 days after substantial completion.
Was there any language in the Sixth Amendment to the effect that it superseded other agreements?
The Sixth Amendment says that if the terms of the Sixth Amendment are inconsistent with any term of the original lease, then it superseded that term. Here, there's nothing inconsistent with one provision that defines landlord's pre-possession obligations to substantially complete the work, and one provision that says if you take possession, you're deemed conclusively to
And that's what you're relying on. The tenant here took possession of 9 and 10, therefore all bets are off.
They're
That's
not
what you're
without
saying.
any remedies, Your Honor. They're
That's what you're saying. But when they took possession and you served them with some notice or whatever, they rejected, like, we're rejecting this. I mean, I know what you're saying. You're saying, look, if you follow the letter of the lease, once the tenant takes possession, physically is in that premises, that's it. All bets are off. The Amendment 6 doesn't even apply anymore.
Your Honor, not that all bets are off. They specifically said, we know there's problems with the HVAC, we want repairs. The landlord committed to making those repairs. It doesn't mean that the tenant has no obligation to pay rent for years while using the space, subleasing the space, and
would it be
staying in possession.
sufficient for the tenant to turn over whatever profits they made from the sublease as opposed to having any rent credit?
The sublease rents
is that a
were way
distinction
less
without a
than what
difference?
the rent is for the premises that they've been in possession with for years. And moving to the second point, as Your Honors, if they were not conclusively deemed to have accepted substantial completion and are only entitled to repairs, then the interim period continues in the Sixth Amendment until 10 days after substantial completion. So if substantial completion was not achieved upon them taking possession, the interim period is continuing, and they have to pay the lesser rent rate that is owed in the Sixth Amendment each month during the interim period. It's a period of time that's defined in the contract. They don't get to take possession and pay no rent for 3 years based on issues with an HVAC that only affects them a few months out of the year. They acknowledge they weren't even in the space for 2 years for COVID, and yet they haven't paid $1 of rent. So in the least, if the court agrees that substantial completion was not achieved, the interim period is by definition continuing, expiring on the 10th day following substantial completion of landlord's work. And during the interim period, tenant is required to pay the lesser rent rate of $92,000 per month. So even if you don't accept the first argument, they are still required to pay the lesser rent rate until the landlord achieves substantial completion. They're not entitled to pay no rent while being in this commercial premises for 3 years, subletting it, using it as a law office, having their employees there. In the lease, they are required to pay
You
the
get
lesser rent amount. And Your Honor, if they're not required to pay any rent, then we would submit that the lease provides for an unenforceable penalty because it allows them to take possession, dispute any item of landlord's work, even removing outlet plates, anything that means there's no substantial completion, and then pay zero rent.
But that's not what they're doing. They're disputing something. As Judge Ostrager also said, why don't you just fix the HVA system instead of litigating this for 3 years or 4 years or 5 years, whatever you've been doing? Wouldn't have that been a better use of?
They are fixing it, Your Honor.
It's taken a long time, a lot longer than the whole renovation. Okay, well, let's hear from the other side, and you'll have a chance to respond. Thank you.
Good afternoon, Your Honors. May it please the court. Landlord's basically coming here and saying, please bail me out from the lease that we negotiated. We wanted to keep Wolf Halderstein in this building. They were looking at other buildings.
So he's saying, I get what he's saying. He's saying the fact that you took physical possession of 9 and 10, that means that the Sixth Amendment, you have your other remedies, but you got to pay me rent.
Sure. You can reach that conclusion if you totally ignore the evidence, you totally ignore the emails, you totally ignore the oral testimony, and you ignore the Sixth Amendment. Then you can reach that conclusion. Because clearly the Sixth Amendment provided that it supersedes 2.4 from the 1995 lease. To the extent it's inconsistent, the 1995 lease was an as-is lease. It was totally different than the Sixth Amendment, which Section 3 laid out substantial work that had to be done. And as Justice Ostrager was puzzled, as were we didn't understand why we're having a trial. The lease was clear. It said substantial completion is to be determined by the landlord's architect. So we say, just show us the determination. We knew there was no determination. We opposed on Yellowstone, we didn't want to pay any use and occupancy because no rent was due under the Sixth Amendment. They sent a fraudulent notice. It was an untruth notice. Dated December 19th, not received until the 27th, and it said, this is a notice of substantial completion. You just heard counsel say they're still fixing it. They are still fixing it. Or we say they're not fixing it, by the way. There's still major problems, but they sent a notice saying it was done. And they, not only did they say it was done, they said, we understand Mr. McAlpin, the landlord's architect, had made a determination. Mr. McAlpin testified clearly that he had not made a determination, and he explained why. Because there were major problems with the HVAC. This wasn't some minor problem. In deposition, he testified the sound was like a jet engine. In trial, he said it sounded like walking into a room with many air conditioners in the same room. There was a problem with air circulation. Let's not forget, on your prior case, one of the prior cases, this court showed sensitivity to the fact that we're talking about a period during COVID. During COVID, we have secretaries, paralegals, associates, lawyers coming in, and the testimony, the evidence from the landlord's independent engineers. Let's not forget the reports of MGE and Walter Gorman, two independent engineers who were the landlord's engineers. We're not relying on some expert from the plaintiff. They said that there was no circulation, that filters were blocked,
Counsel,
that ductwork was leaking.
Counsel, that's your stronger argument. Let's just put that aside for a second.
Sure.
Your adversary then says, okay, we have an alternative argument that we should be getting a lesser rent, I think under $100,000 a month, under the Sixth Amendment. How do you respond to that argument?
Sophisticated parties, represented by sophisticated counsel, drafted a clear and unambiguous contract. That's all I have to, I could sum that up in one sentence.
Where does his claim for that, where is the provision that he was saying that the alternative argument is that you should be paying, continue to be paying an interim amount?
Right, there is no provision. There is no provision. The
I mean,
liquidated,
they would just like that because it doesn't seem fair.
that's exactly right. And by the way, what they're asking you to do is trash the precedent from this court in the Bates advertising case, where this court was affirmed by the Court of Appeals. And they're trying to argue that liquidated damages provision here is an illegal penalty. Now, by the way, the arguments they're making here were not made at trial. Here, with liquidated damages, the Bates decision, which really parroted, in essence, the Court of Appeals parroted what this court said. Bates involved a professional office, just like a law firm. And it said the work was unfinished. In Bates, the tenant had moved into possession, just like this case. And they argued it had not received the benefit of the bargain under the lease, forcing it to occupy space that was less valuable than the top-shelf commercial accommodations envisioned by the parties when they fixed the rent, posing a threat to the employee's safety and security, worldwide computer systems, and its image in the business. The Appellate Division had found that the alterations were a vital part of the deal as a practical matter, it would be difficult. This is what this court said. As a practical matter, it would be very difficult to calculate money damages that it's not reasonably foreseeable at the time of the contract. You don't know what problems will occur. You don't know how long the problems will occur. You don't know the seriousness of the problems, what the impact would be. And all these kinds of arguments were made to this court in Bates. This court said, we're going to enforce the contract because liquidated damages solves that problem of the uncertainty. Went up to the Court of Appeals. The Court of Appeals endorsed what this court said.
Mr. Mullen, did you want to address any of the, you cross-appealed on several other issues. Are any of them something you would want to bring to our attention?
Yes. What happened?
13 seconds.
Yes.
I'll give you a little more time.
Judge Ostrager had his hands full with this trial and the pretrial discovery. You had in this case an agreement, a stipulation that trial would take place in October. Judge Ostrager was giving them 5-6 months for discovery. Why did the landlord need discovery? It was their contractors. It was their subcontractors. This is one of the rare cases where the tenant said, we'll waive discovery, we'll go have a hearing right away. When did you see a landlord who has merit slow walk a case and try to delay it? They ran to this court. Justice Singh was part of the panel. They hired a second law firm. They hired, in the middle of our case, they hired, after they stipulated to the schedule that Judge Ostrager had worked out, October 1, October 4 for trial. And they then hire Morrison Cohn to come to this court and try to overrule, say, Justice Ostrager's trial schedule. And of course, this court rejected that application. That was August 19, 2021. They raised on appeal arguments that they had not made before. Unjust enrichment. Justice Ostrager had, there's no basis for set-off. He dismissed the unjust enrichment on the summary judgment motion. So we go to trial. Unjust enrichment is not part of the trial. We don't put in any evidence with respect to unjust enrichment to show that they're totally separate agreements with the subtenants.
And then he decides that, in fact, it would not be equitable for you to retain the sublease fees if you're not paying the rent.
Correct. It wasn't in the case, and without a motion to re-argue, without a motion to renew, under the Levenger case,
How come it's not part of damages, though, Mr. Mullen? I mean, it's just, it's set off. You could characterize it as set off, not say that you're resurrecting a previously dismissed claim.
One of the worst errors, by the way, the judge did a terrific job dealing with this whole situation. I want to be clear. But one of the most serious errors made was that the use and occupancy, this client tried to show good faith, had agreed to pay $150,000 a month use and occupancy, honored that agreement. Every month they paid $150,000 when they believed no rent was due whatsoever. They paid $1.2 million. And what were the terms of that? Here's what Justice Ostrager said. Supplemental record, page 17. He had assured us that if it is
Counsel, I can't
determined,
I mean, you're way over your time, so, I mean, if
Justice
there,
Ostrager said you get the money back. And instead of getting the money back, he said to Rosenberg and Estes, you're going to pay Mr. Mullen's client back. Instead, landlord, under this decision, unless this court gives us some relief, the landlord's sitting with $1.9 million that should be in our client's possession. That was what the terms were. He made a promise when we agreed and didn't run to the appellate division. We paid $150,000 every month because the judge said,
and he gave that, and now that's rent credit, is that what it is?
now he's
Rent
giving
credit
it
for the
as a
future?
rent credit, which who knows, what will happen and when we'll get it. That wasn't the deal. That wasn't
Okay.
what the court.
Let me give the attorney from Rosenberg and Estes an opportunity to have a few minutes to respond, and then you also will have a couple minutes. Thank you, counsel.
Thank you, Your Honor. To respond to the points, the counsel said there's no provision in the lease providing for interim rent. That's not true. Paragraph 11 defines the interim period as the period.
Paragraph 11 of what?
The Sixth Amendment.
Okay.
Defines the interim period as the period, quote, expiring on the 10th day following substantial completion of landlord's work in floors 9 and 10. Tenant cannot have it both ways. They claim there's no substantial completion, and by definition, the interim period continues until 10 days after substantial completion. And paragraph 11C of the Sixth Amendment says that each calendar month during the interim period, they're required to pay the lesser rent rate.
And what commences the interim?
The interim period is the very beginning of the arrangement when landlords started doing the work, on the new commencement date
So you mean that's
of the
what
Sixth
they
Amendment.
were paying that for?
They were paying that the entire time during the work, Your Honor. And so what has happened here is they take possession, they know the condition of the space, they had all the reports, they knew everything about the HVAC, they take possession, and then their rent obligation suddenly goes from $92,000 a month in the interim period to $0 a month, while they're still claiming there's been no substantial completion. In the lease, they are required, if they are saying there's no substantial completion, and we would submit that they agreed to it and that they're only entitled to repairs and actual damages from the HVAC, but if the court agrees that substantial completion was not deemed conclusively upon them taking possession, then they have to continue paying the interim rent until...
Well, he's making the comment, unless I heard, he said that he was paying $150,000.
That money has all been awarded back to them. They were paying use and occupancy during the trial, but that has all been given back.
Wait. That's not what he said. He said that there were
That
rents.
was not, Your Honor, that was
was actually
all
given back?
100% awarded as a rent credit back to them. The $1.2 million was, they,
The rent credit, it wasn't, he
so
paid
you-
you cash, right? But you gave him rent credit back instead.
the judge
I know the
awarded,
judge gave it, right, okay.
So you were holding it in escrow, or you
it's
got it?
credited against their account, and we submit that if
So
you don't
if-
accept the first point, that they have to continue paying $92,000 a month, that would be offset against the $150,000 that they were paying. So
Okay, so-
instead of returning them,
So what you're saying is, once they start, some court finds that they have to start paying rent, or there's substantial completion and they have to start paying rent, then this will be credited for the first 1.5 million.
That's what the
you're
court
saying.
ordered, Your Honor.
But I mean, the interim period, that as I read it, in section 11 of the Sixth Amendment, that relates to the 11 and 13, the 11th floor and the 13th floor, and that's not where they are anymore. They went back to 10 and 12, 9 and 10, because you wanted to, I mean, you convinced them to go back to 9 and 10, even though it was making all that noise, because 11 and 13, you wanted to demolish those, and as soon as they got out, it was demolished. So that's what the interim period is. So that doesn't, it's not really that this is, that, oh, it's very clear, this is what the interim period said. The interim period said it's for 11 and 13.
Your Honor,
No?
Your Honor, the interim period is defined as the period commencing on the date of the Sixth Amendment and expiring on the 10th
Yeah,
day following.
before the 11th and 13th floors, you're leaving that part out.
It says they were to relocate during the interim period to the 11th and 13th floor, and that period is defined as an expiring the 10th day following substantial completion. This is all reconciled because they were not supposed to take possession until substantial completion. They took possession and have said there's not substantial completion.
So you're saying that they should have refused when you asked them to go back, so you guys
Yes,
could have
they had an absolute
demolished?
right to stay on 11 and 13.
And since they agreed, and, you know, just...
They agreed in exchange for repairs to the HVAC, Your
Didn't
Honor.
you create this problem? You send a notice which your adversary characterizes as fraudulent, that there was substantial completion. It seems to me that you created the situation. And just one more thing, if I were to accept your argument that you're entitled to this lesser amount, am I rewriting out of the Sixth Amendment Section 4 and Section 11? Section 4 dealing with waivers for floors 9 and 10, Section 11 dealing with substantial completion. Those have no meaning anymore, right?
Your Honor, they were paying interim rent until substantial completion, that they then moved in knowing the condition of the space, saying, we're going to move in. And by the way, when they moved in, they emailed the landlord and said, hey, you should be charging us at the
You know what? Then you had to write a better contract. Then you had to write a better contract on the Sixth Amendment, because as my colleagues have pointed out, that interim applies to 11 and 13. You're saying that because now they took possession of 9 and 10, that interim period should continue to be paid, or they should be continuing to pay interim rent. We don't read that I don't read that anywhere.
Now they have to pay zero rent. They were paying interim rent until substantial completion. Now they get to move in and pay zero rent.
As your adversary said, that's a contract that was written and prepared.
Your Honor, if that's the case, then that is an unenforceable penalty. This is, any defect in this work could not be equal to 100% of the
What
rent.
you gotta do is do some substantial completion, just get the work done. And you're done, right?
Your Honor,
That's
the
what Judge
construction-
Ostringer was screaming about. I mean, I wasn't hearing it, but I could read it out of the papers that he was writing. He was screaming, just get it done already.
The construction professionals advised the landlord at the last meeting that the work was going to be substantially complete on December 1st. There's obviously been...
You know what? I got a
major-
feeling there's gonna be a lawsuit between the landlord and the construction professionals.
Your Honor, there's obviously been major issues with trying to remedy some noise with the HVAC, but that only affects them a few months of the year. They're in this space for 3 years, not paying a dime to the landlord.
But you folks negotiated the Sixth Amendment, and you're asking essentially us
to
That is
rewrite
not
it.
part of what was negotiated. They were required to stay on 11 and 13 until substantial.
But you asked
but
them
the
to
thing
leave.
gets me
You,
so-
you requested that they go back so that you could demolish the floors. It's not like they could have went back after they found that there was no substantial completion. You demolished the floors. What were they going to do?
And they did it at your urging, at your request.
They didn't come to you and say, I want to move back to 9 and 10.
You know, you can't.
You guys went to them.
If that's the case, Your Honor, then when they moved and they said there's issues, there's not substantial completion, they then wrote to the landlord and said, hey, we shouldn't be billed at the full rate, bill us at the lesser rate. And
Why
we
would they need
agreed
to do that? They're relying on the Sixth Amendment. It's in their favor.
They wrote back and said, landlord, we should only be paying the lesser rent rate, not the full rent. They agreed that they are required to pay the interim rent. The definition is that they have to pay during the interim period, which expire. I understand.
Okay, I think we got it. Anything else you have?
If I may address their penalty argument.
Okay, you
that-
have 30 seconds.
Just the judge below correctly found that their delay penalties were unenforceable. It was an additional, at the time of executing the Sixth Amendment, they knew they had an absolute right to stay on 11 and 13 indefinitely and pay less rent. They were not subject to any additional damages from delay. They could have stayed there. And in addition, the penalty of 100% of the rent or 200% of the rent is grossly disproportionate to any defect in the work from after they've moved in and have been using the space. Thank you, Your Honors.
Thank you. Mr. Mullen, I'm giving you 2 minutes.
Yes, just very briefly, I'm sure it wasn't done deliberately, but a statement was made that the tenant had all the reports. It's absolutely not true. That came out through pretrial discovery. We didn't have the landlord's reports from its engineers. The MGE report we hadn't seen. There's no evidence of it in the record. The Walter Gorman report we had not seen. These were all the landlord's experts, and it only came out in discovery that the landlord insisted on having. We were prepared to waive discovery because we knew there was no certification by the architect. The second point is on liquidated damages. There are 3 key points. The test is a grossly disproportionate to the foreseeable damages. The case law makes it very clear the burden of proof is on the party challenging the liquidated damage provision.
Is he correct that at some point your client, I don't know if it was you or your client, wrote to the landlord and said, we're willing to pay the interim rent while we're on 9 and 10 until substantial completion?
No, I don't believe that's accurate. There were sometimes there were small charges. We overpaid. The tenant actually overpaid rent, and part of the claim was to get paid back. They paid too much rent, but there was no agreement. And they didn't have knowledge when they were asked. Bear in mind, this was a tenant. This law firm was in the building for approximately 100 years.
I read that.
They had a long-range relationship with the landlord.
But this is a new landlord.
Yeah, the new one, and they say we need to demolish. And in fact, the evidence shows within days of moving down, they actually demolished 11 and 13. There was no ability to go back there and pay less rent. They were stuck, they were in, and they had no evidence at the time of what the problem was because those reports weren't given to them. The second thing is at trial, on liquidated damage, because it's very important to us, they had a burden of proof to put in evidence that it was grossly disproportionate and that it would have been reasonably ascertainable at the time the lease was entered into. They didn't make that argument at trial, so there's nothing in the record that shows that kind of proof. And they rely on the Free People case, and I understand why, except it's very different. Justice Kapnick, you and Justice Oying and Justice Singh sat on the Free People case. And there are 3 key facts. Number 1, some of the delay was caused by the tenant in the Free People case. That's number 1. Number 2, some damages were beyond the control of the landlord. That's point 2. And point 3, the court found that the damages were readily ascertainable at the time of leasing because the tenant's own records had projections of what it was.
Okay, I think we'll need to, anything further, we'll have to just look back to your papers, which are pretty substantial in addition. Thank you both. We gave you a lot of extra time, but thank you for answering our questions.
I thank the court for its patience.
Thank you both. Okay, the next case for argument, you can get ready, is 100 and 130 Biscayne LLC.
Your Honors, I'll ask the court's permission to hear from counsel Timothy Hughes, who's admitted to the bar in California and has been admitted pro hac vice before this court.
Okay, no problem. Thank you very much. Good afternoon, Mr. Hughes. Welcome to the Appellate Division First.
Thank you, Your Honor.
You may take off your mask while you're arguing if you so choose. Okay.
Let me first address the breach of contract claim and its dismissal. The trial court did not find that Biscayne had failed to allege a breach. What it did was it dismissed the breach of contract claim solely based on the agreement's exculpatory provision. But in doing so, the court engaged in zero analysis of a key phrase of that provision. The provision starts off with an exception, and the exception lists 5 or so different bases of exception. The one the court failed to engage in any analysis on was Section 10.01C, which clearly states that willful breaches of the express terms of the agreement are not exculpated. The trial court...
So what are the willful breaches you're claiming in this instance?
The willful breaches that we have claimed are the failure to competitively bid, the failure to get our approval and then engaging in a construction program that essentially did not build spec suites that were tenant-ready. Those spec suites didn't exist. What the defendants did was they gutted 5 floors. There was only approval to build spec suites on 4 floors. They substituted 1 floor for another floor. So they disregarded the essence of the program that was going to generate higher occupancies, that was going to generate revenue, and there was no offsetting revenue. They simply didn't do one of the obligations they had, which was to operate and manage and develop this project as a first-class manager, of a first-class asset manager. So what they did was spend millions of dollars of my client's money, producing no result because they modified the business plan without getting any approval and without any disclosure.
Did they need to get this approval from your client?
Yes. The adoption of the business plan or a modification of the business plan required unanimous consent. If they did not get my client's consent or unanimity, what they would end up having to do is take the decision of my client. There was 11 categories of major decisions that my client, in the event of an impasse, could override. But the business plan was essential to the investment by my client. It was an essential element of their performance, and they just didn't do it. They did what they wanted to do, and the question becomes why? That kind of ties into the fraud claim. They did it because when you look at entities, we all have the understanding we isolate ourselves with LLCs and with corporations, but corporations and limited liability companies do business through people. And there are 2 people at the heart of this, Mr. Yormak and Mr. Peretz. They absolutely control all of the actions. They even say in the LLC agreement that they have the authority without the consent of anybody else to undertake the actions and fulfill the duties of the operating member, which is the defendant in the breach of contract case. So the control is there. They made promises before, which we can address in the fiduciary duty claims, but the willful breaches, they are detailed, I believe, in sections in the complaint in paragraphs 92 and 91. So I may have missed some for Your Honor, but Justice Singh, I will tell you that the 2 biggest were the failure to competitively bid and the failure to do what they were supposed to do in the business plan, and again, modifying it with absolutely no approval, no knowledge, no disclosure to my client, who doesn't find out until they come back to the property, or they go to the property in October 2018 to find out that, well, where are the tenant suites?
I mean, but didn't that harm the defendants as well? They had skin in the game.
I'm sorry?
I'm sorry. Didn't the absence of leasing space to tenants, didn't that also hurt the defendants?
Whether it hurt the
They are 20% investors. They were putting money into that as well. Wouldn't they have some incentive to try to get
I can't speak for the primary investors on the, did you say hurt the tenants or hurt the defendants? It hurt the defendants?
It hurt the defendants, yeah.
To the extent that the defendants are hurt because they didn't have this occupancy, you have to realize that the same defendants, the same people, were getting asset management fees of $420,000 per year.
So that could sustain them, is what you're saying, yeah.
And if you do that for 2 years, the investments of Mr. Peretz and Mr. Yormak was less than $500,000. So they've already covered their risk. They were in a risk-free situation when it comes to their money. Whether they're third-party investors on their side of the
It
deal.
sounds like the last case, you've essentially entered into a poor bargain here, and you're, again, asking us to relieve you of a poor bargain.
No, Your Honor, we're saying that they breached the obligations of the bargain. The court did not have any issues below that the breaches occurred. They did not have any issue, the court below did not have any issues that there was damages flowing from those breaches, and that they were actually, that the obligations were actually breached. So if you're looking at the other side of it, the fraud case and the negligent misrepresentation and the breach of fiduciary case, it's not a poor bargain when you're lied to. And they were lied to. My client's only real position in this was to provide money. Before my client, as my client...
Didn't you also have an obligation to do some kind of due diligence? I mean, these are sophisticated parties entering into a rather substantial commercial agreement about a substantial piece of property, commercial property in Miami.
I think, Your Honor, that we casually state that parties are sophisticated parties. In this case, you have, and it's pled, the plaintiff is based in Australia.
I'm aware of that.
They have no experience in the Miami real estate market. They are told by the defendants, we have the experience and we have the infrastructure, the people to do it there in Miami.
But almost even more so, wouldn't they have to do due diligence? I mean, they're coming from the other side of the world to do business here, invest an awful lot of money, have 80% of the 80% ownership in the company. Wouldn't they have to be, wouldn't it be their responsibility to do a little bit of due diligence?
But what due diligence could you do? You're told by the other side, we are the experts. So you're going to say, well, okay, are they lying to us? The argument that you're doing, if you fall into that argument, you're saying that, well, don't believe us when we tell you who we are. Don't believe us when we tell you we've acquired $1.3 billion. Don't believe us when we tell you that we've done $250 million of projects that are construction. Don't believe us when we say we have a management company that has the people in place and the experience, and not just generally, but they're experienced in the commercial real estate market of Miami.
All right, I'm going to listen to the other side. I mean, I can just say for my many, many years of being on this side of the bench for all of these big cases, I got to say I'm now at a point where I don't think I would believe anything anybody told me, but without a lot of evidence to back it up. In any event, let's hear from counsel for the defendant, and then you'll have a few moments to respond. Okay? Thank you so much.
Good afternoon, Your Honors. My name is Michael Lynch. I'm from Kelly Dry and Warren, and I represent the defendant respondents here. Your Honors, the sufficiency of this complaint turns on two primary issues. The first is whether the nature of the parties' relationship from which gives rise to the types of heightened duties necessary to support their
start actually straight with the breach of contract, because that in some ways is the simplest cause of action to analyze. So why in this instance shouldn't the plaintiff be allowed to pursue the breach of contract claims based on the kinds of arguments your adversary was making with respect to alleged willful breaches?
Sure, Your Honor. So the plaintiffs here did say that they had done their due diligence. They agreed to Section 10.01C of the agreement, which is set forth at page 136 of the record, where the parties waived, excuse me, that's not 136, it's 124. Excuse me, nope. Pardon me, I have it wrong. It is, it's 10.01C, which bars liability for breach of contract except in cases of fraud, willful misconduct, gross negligence, violation of law, or willful or bad faith breach of the LLC agreement.
So that's what they're referring to. It's the last catch-all.
Right, and so willful breach requires the plaintiff to allege facts showing scienter, right? Showing that there's an intent. It's not enough to just breach the contract under this indemnity provision. That it is required to prove an intent. Now, the problem with their pleading on intent is it makes no sense. It makes no sense that the parties, that the defendants here intended to undermine their own substantial investment. It was not $500,000. The plaintiffs put in $5.7 million into this project. They were responsible for money that came in from other third parties. The project obviously was one of many that they do. So the idea that they would just throw all of that away, throw away an $80 million investment for the purpose of chasing $2 million in fees, it's illogical. It's not credible. It's not a credible.
But is that something that we should be deciding on a motion to dismiss? I mean, shouldn't we be assuming the truth of the allegations, giving the plaintiff every favorable inference? Now, within that construct.
Sure, so bare legal conclusions are insufficient for that purpose. There needs to be facts that support that theory. There needs to be a reasonable inference or a credible inference. And here there is no such inference. There is no reason for the defendants in this case to hurt their own cause. It doesn't make sense. It's not a credible allegation. And you know, when you've got.
What about in the context that there was a scheme here, in essence, for the defendants to get a third party involved to sell the building and get more of an equity stake there? Could that maybe show an inference of what the motive was of the defendant?
No, it couldn't. Absolutely not. So that's the for sale provision. That was an option that both parties had to have a right of first refusal to acquire the property on their own. That was given. That offer was made to the plaintiffs here. The plaintiffs rejected it. They didn't want it. Right? So they had an opportunity. They decided they didn't want it. They also complained that the bidding process wasn't done properly when the third-party buyer was identified. So we went out into the market and we showed that it was an accurate bid on the property at that point. So there's no damages that are flowing from that. And it doesn't make sense for our client to undermine its own equity investment and then go out and find another equity investor who's just going to stomp them down completely, again, for $2 million in fees. It doesn't make sense. It's not a situation where they can go out and shop it around and keep the level, the 20% equity that they had. If the property is in fact devalued and they've done it on purpose, they're gonna be hurting their own cause, regardless of who's on the other side of that transaction. And by the way, the allegations around the for sale are not a scheme. There's not, if you look at the complaint, there are not allegations that there was some untoward scheme here. This was a process that the plaintiffs were involved in from the beginning. They knew everything that was going on. They participated in it, and they made their decisions the way they wanted to under the terms of the agreement that they had signed. Any other questions? So I'll just point out, just very quickly, when we talk about the type of duty that the parties had here, this is not a situation where we have an unsophisticated investor, right? They owned 80% of this project, right? They had negotiated for major decisions, 42 paragraphs over 4 pages in our contract of major decisions that they had approval rights over, an additional 10 that are defined in the contract as Biscayne-controlled decisions, which included things like deciding what goes in the business plan. These were not investors that didn't know what they were doing. They bargained to develop that business plan. And the complaints that we've heard just now about how the project went and how the construction project went instead of the leasing, we've not heard or seen any allegation that was a violation of any of the terms, right, of the agreement, that they missed leasing numbers or anything like that. Thank you, Your Honor.
Okay, thank you. Counsel?
My adversary has misstated Section 10.01C for you. What he has done here is what he did in the court below. He tried to get the court to conflate willful misconduct with willful breach of contract. Willful breach of contract is defined and supplied to us by the Delaware court. The Delaware law controls, Delaware law says that a willful breach is one that is voluntary and intentional, or it is an act or a breach that is done with the awareness that you're doing something, and that it is something that you're aware of the probable consequences. There was no analysis of willful breach. It is a benign concept. It does not does not require a showing of bad intent. It doesn't require a pleading of bad intent. It doesn't require a pleading of ill will or maleficence or malfeasance. It is a benign concept. And the court, and the decision is the Kelly v. Bloom case that we cite to you, the court rejected the defendant's attempt to include scienter, bad intent, as part of the definition of willful breach of contract. And it went to Black's Law Dictionary. And it said, you intend to do the act that you did in sum and substance. You were aware that that act would have consequences. In this case, when you don't get the approval of modifying the very business plan that is being presented to my investor, my client, as the reason why you're going to increase occupancy and produce higher revenues, then you know what you're doing. You are intentionally and voluntarily not seeking their approval, but you do what you want to do anyway. So I think that's a critically important distinction for this court to pick up on. With respect to the motive, which goes to bad intent.
I'll give you another minute, okay?
With respect to the motive that was said, we have pled in the complaint that the defendants were going to push Green Oak, Bentall Green Oak, which is a major property owner, and they were going to, they didn't tell us at first, we had to ask and push, are you going to be part of the management team, a member of the new entity? And the answer is yes. So if you want a motive, there's certainly enough in this complaint to say, one, you're getting fees that far exceed your, Mr. York and Parrott's and East End's actual investment. The other money's coming from other people, but you can bilk them the same way as you bilk my client. And if you drive the occupancy down, you drive the revenue down, you reduce the capitalized value that you can sell that building for. And if you're part of the buy team on the other side of the deal, you've just made a hell of a deal for yourself. So it is not in an implausible position that my client has said that here's the intent.
Okay, I want to thank you both for your time here this afternoon and answering our questions. Have a good afternoon.
Thank you.
And the last case for argument is AMK Capital. Okay, counsel, you may begin. You can take off your mask if you want. If you don't, it's okay.
Thank you. Good afternoon, Your Honors. May it please the court. My name is Adam Plotch. I am the defendant newly pro se. I discharged my counsel yesterday, not because I was at all displeased with the work that they were doing, but because I wanted to say something that I'm not sure that an attorney could say on my behalf, which is, I recognize that I made a mistake here in delaying the interposition of my jurisdictional defense. I was aware of the existence of this action almost from its inception because I did receive the mailing containing the summons and complaint.
Could one argue that there was a willful default here then, by you?
I don't believe so, Your Honor, because...
Well, you're aware of it and you do nothing.
But the case law...
And you are a sophisticated party here, I would submit.
I have no legal training, Your Honor. Yes, I am involved in a significant number of cases as a result of the business that I do, which is purchasing properties from foreclosure sales, but I have not spent a day in law school.
But you are a sophisticated party, and you understand what litigation's about.
I would like to believe that, Your Honor. Yes, that is true. And with my sophistication, I would submit, if you would permit a non-lawyer to lecture on the law, there is no case that says that an awareness of an existence of an action imposes any kind of obligation on the defendant to raise a jurisdictional defense within any period of time. To reach that conclusion would be imposing a reasonable excuse obligation on a motion to vacate for jurisdictional reasons. I would point also, Your Honor, I don't know if you'd recall the Board of Managers versus Kidd case. Your Honor was on the panel. Justice Kapnick, you were as well. In that case, I was in the exact opposite position of the situation I'm in now. Now I'm a defendant trying to get my property back from a purchaser. In that case, I was the purchaser at the sale, and the defendant came after the sale took place and raised a jurisdictional argument saying the judgment of foreclosure should be vacated, the sale to Plotz should be vacated, she should get her property back. There was no question, based on evidence in the record, that she was aware of the existence of the action during its pendency. There were emails back and forth between the plaintiff and her, telling her about the action, telling her about the debt, and ultimately she did not move until after the sale took place. And this court held, with two of the justices on this esteemed panel in that case, that the correspondence between her and the plaintiff, the absolute acknowledgement and awareness of the existence of the action, didn't serve as a waiver of her jurisdictional defense. Even if there is prejudice here, even if the delay caused by me resulted in prejudice, the very definition of laches cannot confer jurisdiction upon a court that it doesn't have. That's straight out of Siegel's almost a verbatim quotation. It's been cited many times in many appellate decisions. There is simply no penalty imposed on a defendant who has never appeared, who has not voluntarily submitted himself to the jurisdiction of the court, to raise his jurisdictional argument. I would agree that I should be chastised for having delayed. I would agree that I did not...
So the court denied your application without prejudice, right?
Correct, Your Honor, yes.
And you didn't take the court up on the suggestion to move by order to show cause.
Because I had previously moved by order to show cause and the court declined to sign. I couldn't appeal that because it's an ex parte order and you can't appeal it. So I then moved by notice of motion, and then that was denied as well. And it was August of 2020, it was during COVID, the Supreme Court was essentially shut down, the appellate division was still moving. There was an administrative order in place at the time that barred any progress in commercial foreclosures, so we elected to go the appeal route. I would add that I did file in the lower court a motion to re-argue that order, the order that's being appealed, and it's now been 2.5 years since, and we don't even have a return date. Unfortunately, everything is much slower in the lower court. One of the primary arguments made by the purchaser is, you waited too long, this is taking too long, you're prejudicing me. And so by moving to the appellate division, which was operating at the time in a way that the lower court wasn't, it was an effort to try to accelerate things. I have to emphasize that a judgment that is void for lack of jurisdiction is not cleansed, it's not laundered, it's not sanctified, it's not made kosher by the fact that there is a delay. When a jurisdictional argument is raised, as your honors know, it's a black and white question. It doesn't trigger consideration of the equities. It doesn't trigger judicial discretion. It's a black and white question. Either you were served or you weren't served. And if you weren't served, then all subsequent proceedings are void. The judgment is a nullity, and any deed that comes from that judgment, even if it's not so fair.
Okay, let's hear from the other side, and you'll have a couple minutes to for rebuttal. Thank you.
Good afternoon, Your Honors. Megan Rowe on behalf of the respondents, Magni McHale and Ola Garcia McHale. May it please the Court, appellant's argument relies on the premise that service was not proper. There's a number of arguments here. They can be distilled into two general categories. One is the procedural issue as to whether the Supreme Court properly directed a filing via an order to show cause, and then the merits concerning the actual service arguments and whether the underlying action should be vacated. With respect to service, this case is disposed. Appellant was served in August of 2017. We have a process server's affidavit that provides presumption of service. It was before the court. A judgment of foreclosure and sale was entered. Appellant's affidavit doesn't do anything to overcome that presumption. There's no defect on the face of the process server's affidavit. Appellant admits that he received the mailing from the service of process. He admits that the address in the process server's affidavit is his address. His only dispute is that a specific person with a specific description was not served at his home. An appellant walks a very fine line in his affidavit. He doesn't argue that there was no woman in his apartment on the day of service. And we think that's intentional because appellant was aware of service. He made a strategic decision to attempt to avoid service and wreak havoc on this foreclosure action after the fact. And we submit that it was a poor strategic decision, and he cannot now vacate the foreclosure judgment because he was properly served. That being said, the issue that's before the court right now is whether the Supreme Court properly issued the August 2020 order. At that time, there was no COVA-era order that prohibited entering that order. The two orders that were referenced by appellant are the court's administrative order and then also an executive order, both of which concern commercial mortgages. As this case was disposed pre-COVID, the judgment of foreclosure and sale was entered in 2018. The foreclosure auction was held in February 2019, at which the property was sold to a third party, and then the property was sold yet again to the McHales in August 2019, all pre-COVID. There was no COVID issue here. The foreclosure was not being prosecuted by the plaintiff. There was no enforcement of a judgment and sale foreclosure because the case was disposed. So neither of those orders, either the administrative order or the executive order, would bar an order from the court. And with respect to the August 2020 order, it did not preclude any relief to appellant. It directed him to file his request for relief by order to show cause, at which point the motion would have presumably been decided on the merits. If that order to show cause was filed following the August 2020 order, I expect that today there would be an appeal on the merits before your honors, but that's not the case. So we would ask that, unless the court has any other questions, to refer to our papers and that the August 2020 order be affirmed.
Okay, thank you. You have 2 minutes for rebuttal.
Your Honors, the affidavit of service is defective on its face. I've never seen an affidavit of service like this or an envelope like this. It contains 3 or 4 absolute violations of CPLR 308, which this court and the Court of Appeals and the Second Department and everybody has said has to be strictly complied with in order for the constitutional right to due process to be achieved.
But you've acknowledged that you're on notice. You've acknowledged that. So it seems to me that they're arguably, you willfully failed to answer.
There is no such thing as a time limit for raising a jurisdictional defense. This court has said 100 times that this can be raised at any time. If Your Honor were to conclude that because I had notice of the action, I am then forbidden from raising a jurisdictional defense, Your Honor would be coming to a conclusion akin to the statute of limitations on fraud claims, for example. With fraud, once you know about a fraud, you have 2 years to make the claim. There is no such time limitation on motions for jurisdiction. The plaintiff's evidentiary submissions make it obvious that jurisdiction was lacking. The affidavit of service itself states that the envelope stated on it, foreclosure action, index number, referee's deed. The fact that I may have delayed in asserting, there are 100 cases where people have done this. There cannot be a different law for me than there are for others. I know that I'm not a sympathetic litigant. I understand because of the nature of what I do for a living. I go to foreclosure sales. I've been doing it for 19 years. And then I have to defend against efforts by lienors to foreclose against me. That makes me disliked by the plaintiff bar in the foreclosure realm. But I have the same rights as everybody else. Jurisdiction here was lacking. It's not even an issue of fact. It's apparent on the face of the affidavit of service. In the Deutsche Bank versus Ferguson case, this court dismissed the foreclosure action for lack of jurisdiction without a traverse hearing, simply by looking at the affidavit of service and realizing that it was deficient. This one is completely deficient. It says foreclosure action, referee's deed, index number, return address of a process server. If Your Honor were to say that a delay constitutes a waiver of a jurisdictional defect without an appearance, that respectfully would be a deviation from 100 years of law.
Okay, thank you. Thank you both very much.